on camera. So with that, welcome to our agreement of sale workshop. Good morning, Trent Pettus.
Good morning, Matt. Good morning, everyone. Good morning. I'm singing. Yeah, if you all could, I know some people can't put videos on, but if you could, it actually makes it better than I'm staring at some blank screen. So I get to see all these great looking faces. So I appreciate it. This is interactive. All right. We're going to go through this whole contract, but I like feedback. I know I'm looking at agents who experience. I know we've got new agents. So if you have questions, comments, interject. Don't wait. Can you all see mine's just looking on? If you have questions, comments, just interject. We're not going to wait till the end for questions or comments. We all learn from one another. Every time I do this, there's some agents here I know who you may do things a little differently. So share it with us, and we can all learn together. Okay, this is supposed to be a learning experience, and we should have fun at the same time. All right, that fine with everyone? Can someone say something to me so I know you can at least hear me?
Yeah, Trent. Apparently the beard is getting some rave reviews. So congratulations.
Oh, but thank you, because now I can't tell people I'm 40 anymore. I have to tell my age. And by the way, that's 50. All right, let's get started then. I always like to say, just so you know, I have been in this business. I got a license back in 2000. Started out on Wissahickon. I was working full time at the time. Stayed there only a couple of years. Went over the Remax. Stayed there for many years. Ended up getting my broker's license there after a few years. Was a top producing agent. When after maybe the first or second year, became the manager of 3 Remax offices, trained many agents in my day. Ended up opening my own office. 2010, opened an office in Delaware and licensed in Delaware. And about 5 years ago, maybe 6 now, bought a place in Florida, and I got a broker's license in Florida. So now I'm spending my winters in Florida. I'm heading to Florida next week for the winter. I shouldn't be here now because it's too cold. I think it's inhumane to be in this weather. But having said that, let's have some fun. But and I love this business. But some of you know me. I love this business. And one of the things that I believe how you become successful. Well, let me just say this quick story. When I first started, I was doing this deal with this experienced agent. I think she had been in the business 20 years. It's probably one of my first transactions. And my buyer did not get the mortgage commitment by the date that's in the contract. And the agent said to me, the buyer put down maybe $10,000 earnest money deposit. And she said, Trent, if we don't get the commitment by this date, then your buyer will lose his earnest money deposit. And I said, well, wait a minute. I said, well, that's not the case. She said, yes, it is. I said, no, that's not what the contract says. And I pointed it out to her. And I said, when we look at this contract, and I'll never forget this. This is an agent who's been in business about 20 years. She said to me, I didn't know that was in there. I just thought that if the seller terminated the contract because the buyer didn't get the commitment by the commitment date, the seller got to keep the earnest money deposit. And I said, no. Here's an agent who's been in business for 20 years and done tons of business, but didn't know what was in this contract. I was a brand new agent. But one thing I did when I became an agent, I would read every contract. I would take a page a day or week, and I would read it because I knew it would make me a better agent if I understood, because these are the tools that we use. And if I understood what's in the contract, I knew I would be a better agent. And I would be able to serve my clients better. And so I stand here or sit here today with that same mentality that if we're better agents, we can become more professional agents, and we can service our clients better. And so that's one of the reasons I like to do these seminars, because I think we all, listen, do I know every single thing in here? No. Do I know 99.9%? Probably. I'm sure there's something I don't know. So if there is something, let's educate me also. So let's just get started. Any comments, any questions before we start? Anything anybody wants to say before we start? All right, let's start with the consumer notice. Does everybody have the documents? Documents available to everyone, correct? Donna, everyone has the documents? Can someone say something? Make sure
The link is in the chat.
Okay. All
But
right.
the link is in the chat. It just contains the agreement of sale documents.
Okay. Let's start with the consumer notice. We all know that the very first document you must provide to a customer or client is a consumer notice. Do you know that if no transaction occurs, you, the agent, should keep this consumer notice, a signed portion of the consumer notice, for at least 6 months? Did you all know that? A lot of agents don't know that. If there is a transaction, then it would be in a file, and it should be your broker has to keep it for at least 3 years. But if it does not turn into a transaction, you have to keep. The Real Estate Commission requires that we keep proof that we gave our buyer, our customer, or the clients, the consumer notice. So make sure you keep that for at least 6 months. When you have to give a consumer notice, take a look at it. The consumer notice says, obviously, this is not a contract. Anytime you have what we call a substantive conversation about real estate, I are required to give that customer or client the consumer notice. Substantive conversation. Let's look at the consumer notice. The first paragraph reads, second line says, the RELRA, or the Real Estate License and Registration Act, requires that consumers be provided with this notice at the initial interview. The initial interview is defined by the licensing law as the first contact between the agent and the consumer where a substantive conversation or discussion about real estate occurs. Substantive not meaning, hey, what's the zoning classification? That's not a substantive conversation about real estate. Hey, how many bedrooms? Not substantive. But if you have a person who says, hey, I have a pre-approval from the Navy Credit Union for $400,000, I have $100,000 saved, that's a substantive conversation. And at that point, you should stop the conversation and provide them with the consumer notice. All right. Obviously, the consumer notice will tell us the different business relationship choices that you could have with that consumer. You can be a seller's agent. Clearly, you represent the seller. You could be a buyer's agent. You represent the buyer. You could be a dual agent. You represent both the buyer and the seller. You can be a designated agent. Some offices practice designated agency, which simply means that the broker appoints an agent to act exclusively for either for the buyer or the seller, to the exclusion of everyone else. Because in a real estate office, let's say this is a real estate office, GPAR real estate office. If I'm just going to pick somebody, if I saw Dina is representing the seller in this office, everybody in this office would also be representing the seller, and they would owe that Dina's seller the same fiduciary responsibilities that she would owe. If Dina and Dina represent the seller, Dawn represent the buyer, of course, there would be dual agents, and everybody in this office would be a dual agent. But in a designated agency office, and I'm beginning to see more and more offices that practice designated agency, then if Dina is the exclusive agent of the seller and Dawn is exclusive agent, or let's just say Dina is exclusive agent of the seller, then no one in this office would be a dual agent other than the broker, because no one in the office should have any idea of what is going on with Dina's client other than Dina and the broker. All right. One of the reasons I think a lot of offices practice designated agency is to avoid dual agency. Although you can be a designated dual agent, but I think the reason, because I think I'm getting too far in there. Any questions or comments? Just make sure you keep the consumer notice for at least 6 months if there's no transaction occurs. And a lot of us will just go out, show a property to a client or to a consumer. Well, I guess that should be a client now because of the new NAR, because you can't show a property without a buyer agency contract. But you should keep this consumer notice for at least 6 months if nothing else comes of it. Any questions or comments? All right, well, let's go to the agreement of sale. Let's look at the agreement of sale. First of all, buyers and sellers, make sure in the agreement of sale you put the full name of the buyers and sellers. No nicknames. If they're junior or they're third, you should put these are the legal document. Once it's signed by both parties, it becomes a legally binding document. use full names. I've had contracts in the past that said Bob Smith, and I know Bob is a nickname for Robert. So I had to ask, is a person Robert or is his name Bob? Turned out it was Robert. Make sure you put the full legal name of that buyer, that seller. And if there are multiple buyers or sellers, make sure they have full legal names. Don't have to have the full middle name, but if it's a middle name, you should at least have a middle initial. The buyer's address, seller's address. I know people may disagree with me. I have never put this in. I don't think people need to know where my buyer lives or my seller lives. I don't share this information. And I can tell you one of the reasons I stopped years and years ago when I was writing up a contract, the seller's agent made a comment about where my buyer lived and said something negative about the address or the neighborhood she lived in, and made a comment about whether or not she can really afford to buy this house. And after that point, I never, ever disclosed my buyer's address because we did not get that property. And I followed up, and it turned out when that property closed, my buyer's offer was actually $10,000 higher than what the property sold for. So that's just my own thing. If you like to put, if your office policy is to put it, fine. I just don't put buyers, and I don't think buyers need to know seller's addresses, their foreign address. I don't think a buyer needs to know. I mean, a seller needs to know a buyer's address. That's just my own personal thing. I'm not saying you have to do it that way. Obviously, we have to put the address of the property, the zip code, the city, the school district, where we all see this. Do we see this a lot? Agents sometimes put the wrong school district. Anytime I sell property outside of Philadelphia, it's because why? Usually because they want to go to a particular school district. Don't get the school district wrong. I have seen, and I say this, years ago, I'm sitting in Abington at a settlement, and there's all this commotion. Turns out the seller's agent put the wrong school district or put the wrong elementary school in MLS. The buyer's buying the property because she wants her children to go to, it was a blue ribbon school at the time, this one elementary school. They sit in that settlement, and the buyer says something about she's going to register her kids. And the seller says, oh, no, your kids don't go to this elementary school, they go to the other. Well, the buyer was not happy, and she ended up leaving settlement and filing a lawsuit against her agent and the seller's agent. Her agent didn't bother to check. She is wrong in MLS, is wrong in the contract. You know your client is moving to a certain city or township because they want to be in a certain school district. At least make sure that information is correct. All right, so school district, and I've even seen it where they put the wrong school district in the contract. As the agent, if you're the sales agent, make sure you correct that. Don't have them thinking that they're in a certain school district when they're not. So if it is the wrong school district, it should be incumbent upon you as a sales agent to correct it. All right. Any questions or comments? All right. Tax ID number. Obviously, you can get the tax ID number from MLS or public records. And the tax ID number is just used to ID a particular piece of property. It's almost like a social security number for a property. So even if you had the wrong address, it wouldn't match with the tax ID number. I just believe this. We should not be sloppy when we prepare these contracts. We should take our time. I've seen more problems with these contracts in my 20-some years as a real estate agent. And let me keep going. I'll tell you some stories in a minute. A business relationship with the PA licensed broker. Clearly, if there is no business relationship, you would check that box that says no business relationship. The buyer is not represented by a broker. On the left-hand side, the broker, that's a company, put the license number, address, phone number, and check if the broker is the buyer's agent or a dual agent. On the right-hand side, the licensee or the salesperson's information will go. If there's multiple salespeople, I think it's best practice to put both licensees' information on this contract. We see their license number, their phone numbers, emails, and then what is the licensee? Is the licensee the buyer's agent is a licensee, a buyer's agent with designated agency. If your office practices designated agency, obviously you would check that. And then, are you a dual agent? Clearly, you're a dual agent if you represent both the buyer and the seller in the same transaction, or you're a dual agent if both agents are in the same brokerage. Seller's agent, the seller's relationship, obviously, if you represented a FSBO, if you have a seller who is, if you're selling a for sale owner, you would just check that no business relationship, and the same would apply if you are the seller's agent. And if you can see that box on the bottom, it says transaction licensee. If you're not a transaction licensee, we all know is simply a non-agent. You represent neither party. You're simply doing paperwork on behalf of that client. All right. The date of the agreement of sale. I think you should put the date. It should be the date of the offer. All right. We know dates become really important in these documents. I think it makes sense to put the date that you prepare this contract. It should be the same date that the buyer signs it. Should be the same date that you present it to the seller, as opposed to you writing out the contract today. So you put the December 5th. You meet the buyer December 6th to sign, and you submit it to the seller December 7th. I think it just makes sense to have those dates be consistent, because it becomes an issue when you start doing a bunch of counter offers. So if I know this contract is dated December 5th, I know that's the date my buyer signed it. I know that's the date that I submitted it to the seller. Make sense? No?
Yes, thank
All
you.
right, thank you. Thank you. Somebody, at least one person's enjoying this.
Sometimes that's not very realistic.
We're only 10 minutes in. Most people enjoy these seminars. So am I boring you all?
No, not at all.
All right, thank you,
Not
Annette.
boring.
All right. All right, let's keep going. Purchase price. Obviously, you run right into purchase price. If there is a deposit, let me ask you this, because do you have to have an earnest money deposit for this contract to be valid? Does there have to be an earnest money deposit? Can you submit this offer with no earnest money deposit?
Yes.
No.
Some people think that they'll say, well, that a contract has to have consideration. Well, the consideration in this contract is the purchase price. So it does not have to have consideration, although I don't know a lot of sellers are going to take their property off the market without consideration. Be mindful of the date. Now, here's one thing I also like. It says here, if you look at paragraph 2A1, the initial deposit, if you leave it blank, you have 5 days to get the deposit to the seller, 5 days from the execution date. What is the execution date? The execution date is the date that the last party signs the contract. And if you count in days from the execution date, you never count the execution date. Well, let me go down to paragraph 5. Let me show you that. Paragraph 5C, it says, second line, it says, for purposes of this agreement, the number of days will be counted from the execution date, excluding the date this agreement was executed and including the last day of the time period. In other words, if this contract was fully executed today, and you had 10 days to do the home inspection, you would start counting December 6th. So it'd be December 6th, I think the 15th would be the last day. So you would not count today. The execution date would be the date that the last party signs a contract, usually as a seller. But so going back to your deposit, you have 5 days to get that deposit from the execution date. I don't know if anybody here would agree with me, but I think this is a problem because many times checks don't come in until after this date. Lots of agents don't seem to think this date is that important. Does anybody run into that same issue that you get? No, I'm the only one. All right. Well, the good thing is now seems like a lot of people are wiring the monies to us, and I prefer that because we don't have an issue. But here's one thing that you want to make sure you're mindful of. If you're the seller's agent and you have 5 days, that agent has 5 days to get you an earnest money deposit check, and now here's the 5th day, and you don't have it, you have an obligation to go back to that seller and say, hey, I don't have an escrow check. Well, let's say it's a 6th day. What do you want me to do? Do you want me to put it back on the market? I mean, because technically this buyer has breached his contract. Don't just assume that the check or tell the buyer's agent, oh, it's fine to bring it tomorrow. If that's the case, you should get some addendum signed by the seller extending this date. Because if the buyer does not bring that money by this 5th, then there are consequences, and your seller should know. You should never be making decisions on behalf of your seller. Always let your clients make decisions, give them the facts, and let them make the decisions for themselves, because then nobody can come back and blame you for blame you. Additional positives. Let's say I'm going to go down paragraph B. 2B. Funds, if you are going to close within 30 days, then the check should be certified or wired. Let's read it. It says all funds paid by the buyer will be paid by check, cashier, check, or wire funds. All funds paid by the buyer within 30 days of settlement, including funds paid at settlement, will be as cashier, check, or wire funds, but not by personal check. So if you are working with an investor, and many investors want to close before 30 days, make sure it's either wired or is certified. No personal checks if you're closing before 30 days. You want to make sure that the broker has enough time for this check to clear. I've had checks bounce after 20 days. So 30 days is probably a good time frame to make sure that check is good. C, deposits. This says the default position is that it will be paid in US dollars to the broker for the seller. This contract says the broker. Did someone say something? The broker for the seller will hold the escrow money. If you're going to change that, all right, you could just put broker for buyer, but I caution if you're going.
Don't touch that. You're on the phone though, right, Viv? Give me the phone.
There's somebody.
Yep,
mute
Stephen, we need you to mute, please.
If I'm on paragraph 2C, if you're going to, we now see title companies. I've seen some offices say they're going to title company hold it. It's one thing for a broker. I don't care if any broker holds it. I have a problem with a title company or an attorney holding escrow, and I'll tell you why. Let's look at this. I want to go back to paragraph C. It says that only if you go towards like C, towards the bottom, it says only real estate brokers are required to hold deposits in accordance with the rules and regulations of the State Real Estate Commission. All right. Now, that means a law firm, an attorney, a title company does not have to hold escrow according to the rules and regulations of the Real Estate Commission or the licensing laws. They will have their own escrow agreements. I've seen title companies who will decide after 30 days, if there's no action, they would just automatically give the money back to the buyer. If a title company is holding escrow, you better at least have an escrow agreement and know what happens in the event that there is a dispute. There's never a problem until there's a problem. I would rather have a broker holding monies because we know what a broker can and when a broker can and cannot release that money. There is no, well, let's take a look at that. So let's go to paragraph 26C, because I think it's 26. 26. Let's see. 26B, under default termination of return deposits. I make sure that my buyers understand this, because over the years, if there's ever been a problem, buyers will come to you and say, I gave my check to Ivy, and even though Ivy sent it over to the co-op, they want their money back if they believe they're in the right. So you need to let buyers know that the broker cannot decide who is entitled to escrow in the event of the dispute. Take a look at paragraph 26B. It says, regardless of the apparent entitlement to deposit monies, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to deposit monies when settlement does not occur. Broker can only release the monies on if one of these four things happening. One, if the agreement is terminated prior to settlement and there is no dispute over the entitlement. Well, if there is no dispute, let's say the buyer does a home inspection, says, I don't want to move forward. They sign a release. You know there's evidence of no dispute if the buyer and the seller sign a release and says release the money back to the buyer. There is no dispute. And it says here that agreement signed by both parties is evidence that there's no dispute. You always want to have an agreement. We don't do any verbal things in real estate. Everything should be in writing. So number one, broker can release the money if there is no dispute. And how you know there's no dispute? You have an agreement signed by both the buyer and the seller saying release the money back to the buyer. Number two, if after the broker has received deposit monies, broker receives a written agreement that is signed by the buyer and the seller directing broker how to distribute some or all of the deposit monies. This one, there was a dispute, but it's been resolved. In other words, maybe there was the buyer breached and the seller says, okay, I'm not going to return the money, but if you give me half, we can agree I'll keep half, you take half, we sign an agreement. And the broker then can distribute that money accordingly. All right. So number one, there was no dispute. Broker can distribute the money. Two, there was a dispute, but it's been resolved. And how do we know it's been resolved? The broker's given an agreement signed by both the buyer and the seller, directing that broker as to how to how to distribute the money. Number three, according to the terms of final court order, broker gets an order, a final court order saying the seller, you must turn this money over to the seller, or you must turn this over to the buyer. So a final court order, that means there's no further appeals. This is a final order. Broker is told who he or she must give that deposit to. And number four, if according to the terms of a prior written agreement between the buyer and the seller that directs the buyer how to distribute the money. What is a prior written agreement? Look at paragraph 26C. There is your prior written agreement. In other words, the buyer and the seller, when they sign this contract, have decided up front what happens if there is a dispute. Take a look at paragraph 26. And this is such an important paragraph that if you don't know about, you ought to. Buyer and the seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved, and this says 180 days, whatever you do, don't leave it at 180 days, just half a year. I would put 30, 15, 30, 20. Don't leave that at 100. That's a half a year. I'm going to read it as 30 days. I'm not telling you what to put in there. Your broker may tell you, but I think 180 days is an awful long time to be holding on to my money. Buyer and seller agree that there is a dispute over the entitlement to deposit monies that is unresolved, let's say 30 days. 30 days after settlement date or following termination of agreement, whichever is earlier, then the broker holding deposit monies will, within 30 days of receipt of the buyer's written request, distribute the deposit monies to the buyer, unless the broker is in receipt of verifiable written notice that the dispute is the subject of litigation or mediation. In other words, if you put 30 days, and even if the buyer is clearly in the wrong, the buyer, after that 30-day period, can send a letter to the broker saying to the broker, please return my earnest money deposit. Once that broker receives that letter, the broker has no choice but to return that money unless the seller has either initiated litigation or mediation. And if they do it after the fact, they still have to return the money. So once that broker receives that letter saying, hey, broker, the seller has not initiated any litigation or mediation in this matter, return my money, the broker then has 30 days to return that money. All right, take a look. Let's continue reading. If the broker, let's go down. Broker will continue to hold the money until receipt of a written distribution agreement. That's what I want to say. I wanted to say. Well, let's go further down. Once the money, so just be clear. If you represent the buyer who breached the contract and you have, for instance, 30 days in there, after that 30-day period, your buyer can simply send that letter and the broker has 30 days to return that money as long as that seller has not, as I said, initiated litigation or mediation. Now, simply giving the money back does not mean that the seller is still not entitled to it. It simply means that it's now in the hands of the buyer. Go down to the last couple of lines there where it says that the buyer and seller agree that the distribution of deposit monies based on the passage of time does not legally determine entitlement to deposit monies, and that the parties maintain their legal rights to pursue litigation even after a distribution is made. So the seller could still come back and file something claiming, that they want this money. But the good thing is, if I'm the buyer, is in my account and not in the broker's account. And if it's not a lot of money, I've served on professional standards and I mean, arbitration. Most people are not going to file a claim for a couple of $1,000s. When you get to 10, 15 higher, you probably will. But 5,000, I bet you if that 5,000 released back to that buyer, the seller's never going to do anything. So this is a good thing for you to know when you represent the buyer. But it's also important, I believe, to tell buyers that you, as the broker or the licensee for that broker, cannot determine who is right or wrong when there's a dispute. And these are the only 4 conditions under which that broker can release that money. Any questions or comments? Can somebody say something, please? Because I feel like can somebody just add something? Just say something. It's a nice day. Say something, somebody, please.
This is super interesting.
What was it?
It's super
I don't
interesting.
like just doing all this talking. I like interchange. Somebody, no questions, no comments?
I have a question.
Thank you, Annette. Leave it
Hey,
to
Trent. I know you're enjoying that weather. All right.
No, I'm in Philadelphia. I'm not going to Florida till Saturday.
Oh, okay. You will be. All
I
right.
will.
So in regards to the money, because we know that's always, the big conversation.
Right.
If the seller, in order for them to get the money, they have to pursue some kind of legal action within that 30 days?
Well, no, they have to initiate either litigation, mediation. It doesn't have to be 30. Well, if it's 30 days in the contract, right. If they didn't do anything in that 30-day period, and then the buyer sends a letter to the broker to ask him for the money, that deposit, then the broker would have to return it. Yeah, if the seller didn't do anything, now the broker can't say to the seller, hey, I just got a letter from the buyer asking for the money, and then the seller can't run down to a lawyer and initiate litigation. The broker still has to return that money to the buyer. So, and the purpose behind this is so that if you are the seller and you believe you're entitled to the money, then you ought to do something. I mean, you should be file litigation, file mediation. Our contract says we have to go to mediation first, but you should be doing something. The fact that you're doing nothing probably tells me that maybe you don't really think that you're entitled to the money in the first place.
All right. So if they file mediation, then the broker's got to step back, and the broker's got to be served with the mediation documents, right?
Right.
Okay.
They have to be, and then it just stops, and the broker cannot distribute the money. The broker has to hold it until one of those 4 things happens. Yes.
But if the seller doesn't do anything and the time expired and the broker returns the money, the seller still has the option to go to litigation? Okay.
Yes.
All right, great. I never knew that.
Yeah.
Thank you.
Yeah. And so, Trent, just to be clear, this is not about the broker releasing the money is not about anything, no final legal disposition. It's just about getting the broker out of the way of the dispute between the seller and the buyer, correct?
I would agree with that. I think that's a nice way of putting it. And you know what? There's another thing, and I agree with that wholeheartedly. But another thing I want you to just note. Now, sometimes buyers, well, let me ask this. If the buyer says to the broker, please give me the money, and the broker says, I can't, because I can't determine who is entitled. And the broker files a loss, and the buyer files a lawsuit against the broker, would the buyer have to pay the broker's legal fees? Anybody?
That again?
Yeah,
Let's say the broker's holding the buyer's money. Buyer says, and there's no resolution, so the broker can't distribute the money. And the buyer says, I gave you my check for 10,000, and if you don't give it back, clearly the seller breached the contract. Let's say the seller is clear the seller breached the contract. Buyer says, return my money. Broker says, I can't until one of these 4 conditions is met. And the buyer says, I'm going to sue you, broker, because you hold it on to my $10,000 earnest money deposit. If that buyer names the broker or the licensee in a lawsuit, would the buyer have to pay the broker or the licensee's legal fees?
I think if the seller, well, if the seller wins, oh, I'm sorry, go ahead.
Somebody who was saying,
I don't know. I was going to say if the seller wins, doesn't the buyer have to pay all the fees?
no, forget about when, just filing a lawsuit. If your buyer files a lawsuit against you, Annette, because you're not returning his or her earnest money deposit, can you now go hire a lawyer and make that person who named you in a lawsuit pay your legal fees?
Is it within the
that's going to happen. That will happen.
Within the time frame of the agreement of sale? Within that 180 or 60 days?
Let's say the broker, for whatever, yes.
I'll say yes, but it's a sheer guess.
All right, and your guess would be a good guess. Since we're talking about, look at 26, so people don't understand that, because make sure, because once I got a letter from an attorney, because I was a seller, so we were holding escrow, but there was an issue and I couldn't release it, and I get a letter from an attorney saying they're suing us, and I said, well, let me show you the agreement of sale, because I'm going to go hire the best attorney in Center City, and your client's going to pay for it. Take a look at it. Look at paragraph 26D, where it says that buyer and seller agree that a broker holds or distributes deposit monies pursuant to terms, blah, 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 will not be liable. So the broker's it's not liable because that broker is following the licensing laws and the rules and regulations of the Real Estate Commission. That broker cannot distribute that money. All right. Says buyer and seller agree that if any broker or affiliated licensee is named in litigation regarding deposit monies, the attorney's fees and costs of the brokers and licensees will be paid by the party naming them in litigation.
But
Which is what is the agreement of sale thing? I'm sorry, I didn't mean to cut you off.
No, I'm reading from the agreement of sale. This is paragraph 26.
Right, I know you are. That's why I posed it as a question. When you asked the original question, I said, what does the agreement of sale say? Because I knew what the agreement of sale said.
Yeah, I kind of that. Okay.
What if, can I ask the scenario, what if the time frame, the 180 or whatever days you have in there, expire and the broker did not return the monies?
But that's a different issue. That's a different, because the broker is mandated to return it. Now you should file something against the broker. You as the buyer.
But my question is, the broker, it would be responsible to pay the legal fees because he was in the wrong by not returning it, correct?
I would probably argue yes to that. First of all, I would file some type of complaint against that broker, because that broker is mandated to return that money after this period. If the buyer requests it, the broker cannot say that I'm not going to return it to you. The broker can't do it. I would file some type of complaint against the broker, because the broker would definitely be in the wrong. All right. Let's go back. Let's go back to page 2. Let's go back to seller assist, since we, paragraph 3, seller assist. Oh, now we've got the new contract. I'm sorry. Let me go to paragraph 3. We know that's the only paragraph that's changed since the NAR settlement agreement. Now we have seller concessions. A is buyer broker fee. That's basically our commission. How much commission are you paying? And B would be the closing cost assistance, which is what we know as seller assist. So now here's what you don't, if you call the seller's agent and ask if there is cooperating broker compensation, and if so, how much, then you can just put that in agreement. Let's say they tell you 5%. I'm just making up a number. They say the commission is 5% being paid to the buyer broker agent. Then you would just put 5. You can also use the cooperating broker compensation. I think this is just easier, but you can't use them both. If you use them both, then no, let's say you use a cooperating broker compensation because the agent said to you that is a 5% commission and you put 5%, then you would put 0 in the agreement of sale because this says, look at this. It says in a buyer broker fee, that's our commission. In addition to any cooperating compensation negotiated between the brokers using the cooperating broker compensation agreement. So in addition to, okay, so if you have a cooperating broker and you put 5% that the seller is paying the buyer's agent, then you will put 0 here. If you didn't use the cooperating broker compensation and the seller is giving you 5%, then you will put 5%. What you could do, for instance, let's say you are the broker. Well, I don't even get into that. Does everybody understand that? They work together. You can't put 5% in the cooperating broker and then 5% in agreement sale. Then the seller, you're saying the seller is giving you 10% commission. Everybody with me?
Yes.
All right. All right. Settlement and settlement and possession. Settlement date. Make sure the settlement date is my niece just is her husband moving to Dallas and they close this week. And she had called me and he put her agent put Thanksgiving Day as the settlement date. And she called and she said, Trent, are they open on Thanksgiving? I said, no, I don't know any title companies open on Thanksgiving. And this title company, Virginia, happened not to be even open the next day. And of course, then they were open the weekend. So she caught it. The seller's agent, the buyer's agent put in Thanksgiving Day. Her agent didn't catch it. My niece had to catch it a couple of days before settlement. She's thinking, oh, well, she was okay with even closing Thanksgiving. She didn't know. This is her first house. And I just thought, how do you not, when you're writing up a contract, at least have a calendar in front of you. I remember getting a contract that had the 4th of July as a settlement date. You can't tell me you don't know that that's a holiday. The 4th of July, I've had weekends, and just have a calendar and make sure you put in a business day that's not a religious holiday, that's not a holiday. And just, again, I just think that's just sloppy. I think that's just lazy. All right, just it's good now. Well, I don't want to say anything else. So make sure your settlement date, have a calendar when you fill out that. And settlement, who pays a transfer tax? Go down to F. Transfer taxes are divided equally in this contract. Obviously, everything in this contract is negotiable, but if you leave it as it is shared equally. The transfer tax in Philadelphia is 4.278%, and it's split 2.14% each. 3.278 goes to the city of Philadelphia. 1% always goes to the Commonwealth of Pennsylvania. The possession, another big one for me, G, when possession is to be delivered by deed, existing keys, and physical possession to a vacant property free of debris, with all structures broom clean. You cannot leave your junk if you're the seller. You can't put your old sofa in the backyard. The property must be free and clear of all your personal items. Sometimes sellers think if they put the bed in the backyard, it is okay because it's no longer the house. Make sure your sellers know that it's broom swept clean, no personal items whatsoever. And I'm sure you all have gone in properties, your pre-settlement walkthrough, and you still find a sofa in the basement, or you find some personal items. Just make sure if you're the seller's agent that all that stuff is removed. I always go by the house to check myself before a buyer's agent will even come back, because I want to make sure everything is out. If you are the seller, let's say you are selling a multifamily property. Let me get, you're selling a multifamily property. It's a duplex. One unit is becoming, you're selling it, you're going to sell them at the end of December. One unit just came available. All right. seller says, oh, I'm going to put my daughter in this unit and give her a 1-year lease. The market rent here is $3,000. I'm charging her $1,000, and I'm gonna give her a 1-year lease. Could the seller do that?
No.
All right. Could the seller extend? Okay, I would agree. No. The contract, the lease expires today. Could the seller extend the lease of the existing tenant?
That's a tricky one, but perhaps so.
All right. Would anybody else? What would you all say? Could seller, your buyer is purchasing the property December 31st. Well, that's a holiday, right? December 30th. The lease expires on one of these units today, December 5th. The great tenant, rent is $3,000 a month. Tenant wants to stay. They want to renew. They want another 6-month lease extension. Can that seller extend that lease without your permission?
No.
I would say no. I would say no. I don't mean to cut you off. I would say no because I extended the lease. The sellers created an encumbrance upon the property that did not exist prior to, so they created a new encumbrance to the property.
Yes, he will be able to sell it, but wouldn't he have to give over the lease to the new buyer, the buyer?
Yes, but let's take a look at your contract. Look at paragraph 4H, third line down. Seller will not enter into any new leases nor extend existing leases for the property without the written consent of the buyer. So the answer is no. The buyer would have to agree to it. Because you think about it this way. What if the buyer is buying the property and they're going to live there? If they have an FHA loan, they have to live there. That has to be their primary residence. So if they can't live there, they're not going to get that FHA loan. And so maybe they buying it to live. And now if a seller has the opportunity to extend the lease or put a new tenant in, then maybe this buyer wouldn't have bought this property. So no, the seller cannot do that unless they get permission from the buyer. Zoning, paragraph 6. Do you have to put the zoning classification in this contract if it's zoned solely or primarily as a single family dwelling? Does a zoning classification have to be in the contract if it's zoned for residential purposes only?
No.
The only time zoning classification has to go here is if it's zoned anything other than residential. However, I think it's a good practice to still put the zoning classification no matter what it is, even if it's residential. I always believe that if you leave blanks in a contract, I never know if the agent meant to leave it blank or forgot to insert something. I don't leave blanks. I'm either going to put NA or even if it gives, let's look at this under zoning. Failure of this agreement to contain a zoning classification, except in cases where the property is zoned solely or primarily to permit single-family dwellings, will render this agreement voidable at the buyer's option. So if this property is zoned anything other than residential and you don't put the zoning classification, then the buyer can void this contract. So you want to make sure that the zoning classification's here. If it's other than residential, I believe you should put it there even if it's residential. I think it's a good practice. Just put the zoning classification in there no matter what it is. Would you all agree with me? Some experienced agents, would you agree with that?
Yes.
Yes.
I agree.
Hey, Trent, I would also suggest to people to go to atlas@phila.gov to verify. Because sometimes the stuff's not right all the time on the MLS.
Well, and I'm glad you said that, Annette, but take a look at that last line under zoning. And it's in bold. It says zoning classification as set forth in the local zoning ordinance. So whatever Philadelphia has it at, the zoning is not what the seller says it is, not what you think it is, not what some other sites, because there are some sites that I agree with you that are wrong. Whatever the city of Philadelphia says it classifies as a zoning, that's the zoning classification that you're using. What the local zoning ordinance says. So if Montgomery County says this property is classified as ZIT, is zoned here as ZIT, that's what you have to use, not something from some other site. Because there are a lot of sites out there, and I would agree that there's a lot of misinformation. Any questions? It's paragraph 7, fixtures and personal property. This gives you a list of everything that's going to be included. What you need to remember is anything that's affixed to the property is real property. Anything that is movable that you can lift up and take out is personal property. Personal property, I always say, goes with the person. Real property goes with the property. Personal property should not be left in the property. And all of the things that are here that is included in the sale, this is basically, well, some of them could argue it could be, but they give you a list so that you cannot have a problem. It says including this sale are all things permanently installed in or on the property, including plumbing, heating, gas, fireplace logs, radiator covers. That's a good one. People like to take those. Lighting fixtures, including chandeliers, ceiling fans. To me, I always call this a chandelier paragraph, because sellers sometimes would take antique chandeliers and replace them with some chandeliers they got at the dollar store. Whatever was in this house when your buyer looked at it should be there when your buyer comes back to do the pre-seller walkthrough. I've had sellers take a very nice refrigerator and go out to scratch and dent and get the cheapest one that they could and take the expensive one. You have to tell sellers whatever was here when the buyers looked at your property should be here when your buyer comes back to purchase this property. You can't swap out expensive appliances for cheap appliances. All right. People will do that. So make sure buyers understand what's in that property to look at it. Pools, spas, hot tubs, all this stuff has to be included. You can scratch out anything. Remember, everything in this contract's negotiable. Garage door openers and transmitters, mounted brackets and hardware for television and sound system, shades and blinds, awnings, a range. Just if there's anything in the next paragraph, if there's anything that you want to exclude, you could put under paragraph D. If, for instance, they're taking the shades and blinds with them, you can put that as excluded item. I would probably cross it out and also put it as excluded item to make sure it's clear that the seller is taking that. Any questions or comments? Let's talk about buyer financing. I want to go by, can the buyer, all right, look at what is that? Paragraph 8F, mortgage contingency. If the buyer waives the mortgage contingency, does that mean the buyer is paying cash?
Necessarily.
Not necessarily. If the buyer waives a mortgage contingency, can the buyer still get a mortgage loan?
Yes.
Yes. Does the seller have to cooperate with the buyer, with the lender, if the buyer waived the mortgage contingency but decides to get a loan?
Yes.
Yes. If you have a client who is going to pay cash, they're waiving the mortgage contingency, but they're actually paying cash, I think it's better to put in your contract that this is a cash transaction and with no mortgage, that the person's not getting a mortgage loan, they're strictly paying cash, because that is a difference. I think it's a stronger offer. If there are competing offers and your offer, we both waive the mortgage contingency, but you may or may not get a mortgage. But my contract says this is strictly cash and there is no mortgage loan, then that means the seller doesn't have to be concerned with an appraisal. I mean, it doesn't matter what the value is, but I'm saying that they don't have to let an appraiser in. They don't have to be concerned if the lender comes back and says we want repairs. Obviously, the seller doesn't have to do any of that because you waived it. But then, in order for that buyer to get the loan, the repairs may have to be done in a house. They may have to pay for it. But my point is, if it's a strictly cash transaction, note that it's a cash transaction because your offer will be stronger than the person who waived the mortgage contingency but plans to get a loan. That,
And
do you all
where
agree with
would
that?
you indicate that?
Maybe on the additional terms.
Is there evidence of funds form?
No, and the contract, just on the additional on page, I would just put it in,
The final.
yeah, on the
final
additional
section.
term, on paragraph
Okay.
32. I would just note in there that this is a cash transaction. You know, buyer will not be getting a mortgage loan. That's different from waiving a mortgage contingency and getting a loan. I would take, if I'm the seller and I have two offers, one is clearly cash and the other may or may not be cash, and everything else is equal, I'm going with the one that says this is a cash transaction. If
Even
everything
if
else
they
is
change their minds,
well, you can't change your mind if it's strictly
or it would
cash.
still be a cash offer, but they could change their mind and still get a mortgage.
Well, no, not if you put in the contract this is a cash transaction. You can change your mind if you waive the mortgage contingency. You can get a loan or you can not get a loan. But what I'm saying, if it's strictly cash and you put in a contract, this deal is strictly cash and the buyer will not be getting mortgage financing. The buyer couldn't change his or her mind because without the seller agreeing.
They'd have to do an addendum or something.
Right.
Okay.
And I don't know, right, if the seller agreed to that. All right.
If you waive the mortgage contingency and the buyer does get a mortgage and the seller refuses to let the appraiser in, can he do that?
They can't, because now they have breached the contract, because they have to go to the page. Look at paragraph 8. It speaks to that. Look at paragraph 8, buyer financing. Now look at it, says the second line says, regardless of any contingency, that is whether you waive the mortgage contingency or not, regardless of any contingency elected in this agreement, if buyer chooses to obtain mortgage financing, the following shall apply. Number 1, buyer will be in default of this agreement if the buyer furnishes false information. Obviously, buyer has to well, let's finish it. If the buyer furnishes false information, anyone concerning the buyer's financial and or employment status fails to cooperate in good faith with processing the mortgage loan application, fails to lock in a rate, or otherwise cause the lender to reject or refuse approve. So buyer would be in default if they didn't cooperate in good faith with the lender. Number 2, within and leave. Now again, this is what I was saying. This says this is blank. But if you leave it blank, it's 7 days. I always think it's a good practice. If you want it to be 7 days, type in 7. That way, when a listing agent gets it, the listing agent knows that you meant to put 7 and that you just didn't forget. I think it's always a good practice, just type it in there. But let's go. Let's say it's 7. So the second point, if regardless of whether you choose to waive the mortgage or not waive the mortgage, you have 7 days to make a loan application. If you do end up getting a mortgage, all right, you have 7 days to make a loan application from the execution date. If you think you need more time, then put more than 7 days. Put 10 days, put 12 days, whatever you think your client needs. All right. Here's something that a lot of brokers or agents don't seem to know, and even lenders. I've had to send this contract to lenders. Look at this last couple of lines on the paragraph 8A2. It says, broker for the seller is authorized to communicate with the mortgage lender to assist in the mortgage loan. Broker for seller, if any, is permitted to contact the mortgage lender at any time to determine the status of the mortgage loan application. Sometimes lenders, when you call them, they say, well, I can't discuss this loan with you because I can only discuss with the buyer. You can say the buyer has agreed in the contract. I can send you a copy that they agreed that I can contact you, lender, and get a status report. Most lenders will not communicate with you, but unless they have permission, and some of them don't know this here. If you have to send this to them, if you need to communicate with the lender, then you should do that. Number 3, so number 1, so note the buyer has to cooperate with the lender in order to get this loan process. Number 2, the buyer has to make a completed mortgage application within, if you leave it blank, 7 days. Number 3, here you are, seller will provide access to insurers, representatives, and as may be required by mortgage lenders, to surveyors, municipal officials, appraisers, and inspectors. But go back to that first line. It says, regardless of any contingency elected. So even if the buyer says, I'm waiving the mortgage contingency, this contract says under 8A3 that the seller will provide access. So if the seller will not provide access to that appraiser, then the seller could be in breach of this contract. All right. And the fourth, the buyer would have to lock in the rate. If the lender allows the buyer to lock in the rate at the level that at the maximum level or lower that they put in the contract, they need to do it within 15 days of settlement. Any questions? And while we're here, and if you go down to that box, the FHA VA box, if your buyer is getting an FHA loan or VA loan, then the property must appraise for the purchase price or higher. And that's basically what C says. If you see that blank, it would be the purchase price. If you're filling this out and you have an FHA or VA buyer, if the purchase price is $400,000, then the purchase price will go in that blank where it says the lender, the appraised value of the property of not less than, you see a blank, the purchase price is stated in the contract. So what if it's only if it's FHA or VA, where you fill out this box and the purchase price will go in that line. So the property has to appraise for the purchase price or higher in order for that buyer to qualify for that FHA or VA loan. If the price appraised is lower, then obviously you have to go back and either ask a seller to lower the price, or the buyer can move forward with that, but just have to make up the difference in price. Also, in that same box under D, make sure if you represent a buyer, you have an FHA or VA buyer, that you provide them with for your protection, get a home inspection. That is, HUD rules require that lenders or the agent provide this notice to the buyer before signing agreement sale, okay? So you have to provide that buyer, doesn't matter who does, I would do it myself, but the lender could do it. But for your protection, get a home inspection must be provided to a buyer before they sign the agreement of sale. All right. Any questions or comments? All right. So go back to look at the box for the first mortgage. So if you are getting a loan, if you elect, well, let's look at elected. So first, if they waived it, this sale is not contingent on mortgage financing. Although buyer may obtain mortgage financing, buyer and seller understand that the waiver of this contingency does not restrict the buyer's right to obtain mortgage financing for the property. And we know if they waive it and they choose to get mortgage, they choose to get a loan, the seller has to cooperate with that lender. All right. They can't say, well, you waive the mortgage contingency, so I'm not letting in an appraiser. No, we already know that they cannot do that. All right. So if a buyer elects home to get mortgage financing, it says this sale is contingent upon buyer obtaining mortgage financing according to the terms outlined below in this box we'll talk about in a minute. Last line here, it's important. Buyer will promptly deliver a copy of the documentation to the seller, but in no case later than blank. That is your commitment date. So whatever date you keep in mind, that your commitment date, once you get that commitment and there are conditions that need to be addressed, your buyer needs time to address those issues. So don't put a commitment date 2 days before settlement. It's probably better to put it 10 days before settlement, 10, 12 days, because the commitment usually gives you 7 days to address these issues. But you want to give the buyer enough time to get any documents that the lender is asking for, or any information the lender is asking for, and the conditional approval. So commitment date, don't make it too close to settlement. 10, 12 days or 15 days before settlement is probably enough time. And so if you are getting a loan, a mortgage loan, then you have to put, now, sometimes I've seen agents will just say they're getting a loan from a reputable lender. If that's the case, then they can go anywhere they want. I wouldn't accept that. I want to know where you're getting it, but if they could do that. But if you are, you put in down the loan amount, you put in down the minimum term, if it's 15, 30, the type of loan is a conventional loan, is an FHA, is VA, And for conventional loans, basically, what's your LTV? 80% LTV means you put 20% down. 90% LTV, you put down 10%. So how much, and then what's the lender's name? The credit union, TD Bank, you know, wherever. And the interest rate, right? Your interest rate, the interest rate, the first line, the buyer, let's say the buyer is willing to take an interest rate, I'm gonna say 6% to 6.25%. So the first line, the interest rate, if you put 6%, however, buyer agrees to accept the interest rate as may be committed by the mortgage lender, not to exceed a maximum interest rate of, let's say, 6.25. So if you put the range of 6 to 6.25, and the buyer can only get a rate of 6.3, would the buyer have to go forward with this deal? You put you put in here that the buyer is willing to accept a loan, an interest rate of between 6% and 6.25%. If it's higher than 6.25%, can the buyer walk away and get his or her earnest money deposit back?
Yes.
Yes. They don't have to go higher than the maximum, but let me ask it this way. What happens if the lender comes back and says, I'm not giving you a 6, I'm gonna give you a 5.5? Would the buyer have to go forward with this transaction?
Say yes.
That's the lower rate?
The lower rate.
Lower than the lower.
Yes, if it's lower, they have to. They can't say, no, I want between 6. If it's lower than what they put, if it's lower than the maximum, then yes, they would have to go forward with it.
But what if the agreement of sale says the mortgage lender is ABC and you have a pre-approval from ABC, but the buyer went to DEF company and DEF declined them? Does the
Well,
seller?
they really have breached the contract, right? Well, what you should do, and what happens, you and I both know that most sellers won't, as long as it's a legitimate lender who's given a pre-approval, they don't care. Sometimes you can get a better deal at another bank, but what you should do is get an addendum, because technically you're supposed to be using the lender that's here. Can you go out and find other pre-approvals? Yeah. And I don't think any seller is going to say, now, what if you put in here that you're getting a conventional loan, but now you change to FHA? Well, some sellers may have a problem with that and may say, no, you need to stick with the conventional loan because this isn't, you know, I'm not going to have to do repairs probably. It's an easier loan to close. I can probably close it faster. So if you're going to change anything here, my advice is to get an addendum signed by both the buyer and the seller.
But if you didn't get an addendum and they changed the lender and the lender didn't approve the loan, does the seller have a recourse?
The seller, the buyer would, right, but I would say that they may lose their earnest money deposit.
Okay, thank
Yeah,
you.
absolutely, because they are supposed to use a lender they put here. If they change it and then they didn't get approved, then the buyer, yeah, I would argue that the buyer could probably, the seller would argue that you defaulted and I'm going to keep your earnest money deposit. I didn't, it's not like if you didn't get approved, if the lender comes back and doesn't approve you, the lender that you put in this box doesn't approve you, clearly you can get you're entitled to your earnest money deposit, but not if you go changing things. This is a contract. You have to adhere to the terms. That's what time is of the essence means, that you have to adhere to the terms and the time limits in this contract. You can't just arbitrarily make changes, and you have to, both parties have to agree to those changes. Anywhere you see in this contract, in this agreement sale, anywhere you see it, and there is an opportunity to terminate the contract, either the seller or the buyer, is the buyer entitled to his or her earnest money deposit?
If it's legitimate?
If anywhere in this contract, this buyer or the seller terminates his agreement, is the buyer entitled to his or her earnest money deposit?
Yes, up until when the contingencies are met.
Now, I'm not putting the conditions on it. If you terminate it, no conditions. Anywhere where the buyer can terminate this contract, the seller can terminate it, is a buyer entitled to his or her earnest money deposit? No conditions.
No.
Give me one where they wouldn't be.
Where they wouldn't be entitled to it?
Yes. You just said no.
I didn't say, somebody else did, but I just wanted to clarify.
The answer is yes. Anywhere in this contract where the buyer can void the contract, let's say they can void it because you didn't put the zoning classification, if it was commercial, for instance, if they terminate it because of home inspection, they terminate it for a host of reasons. They're always, anytime you see terminate in this contract, that buyer is entitled to his or her earnest money deposit. If the seller terminates, there's only one place in this contract where the seller can terminate the contract. Where is that? Seller can, let's look at that. Look, we're back on, still on page, on the lending, mortgage financing. Look at paragraph F1. If the buyer does not give the seller the commitment by the commitment date, the seller can terminate the contract, right? Take a look at paragraph 8, is it 8F2? It says, seller may terminate this agreement after the commitment date by written notice of the buyer if the seller does not receive a copy of the documentation demonstrating the mortgage lender's conditional or outright approval of the buyer's mortgage application by the commitment date. And so some other things too, but if the seller does not receive the commitment by that commitment date, the seller can say, I terminate this. Is the buyer entitled to his or her earnest money deposit back?
Yes.
Yes.
Yeah. If you go down to paragraph 4, only thing you have to remember, you shouldn't even have to think about it. Anywhere in this contract where it says that the buyer or the seller can terminate this contract or the buyer can void this contract. For instance, if you have a condo and the buyer gets a condo docs, they have 5 days to void the contract. They're not happy with the condo docs. Anywhere where this contract allows a buyer to void it or terminate it or seller to terminate, the buyer is always entitled to his or her earnest money deposit back. Take a look at 4, paragraph number 4, I think is 8F4. If this agreement is terminated pursuant to 8F2, or the mortgage loan is not obtained for settlement, all deposit monies will be returned to buyer according to the terms. So the seller can terminate it if the buyer does not get his or her commitment by the commitment date, but the seller would still have to return the earnest money deposit to the buyer. Any questions or comments? Is this, what time is it? Do you all want to take a, well, let's wait. What time is this? Let's go a little longer then. Any questions or comments? Is this helping you all? Is this
Yes.
good or?
Very helpful.
All right.
Hi, I have a question. This is Carmen.
Yes, hi, Carmen.
Hey, okay, so what if the buyer just decides to cancel for no reason at all?
Then they breach the contract.
They'll lose their deposit, right?
Right. You can't just cancel, or you can't breach the contract willingly, then you would probably lose your earnest money deposit. I'm talking about terminate, because the buyer has a right to terminate for different reasons. Like, for instance, buyer says there's a home inspection contingency. Buyer does a home inspection and is not happy with results. The buyer has the right, according to his contract, to terminate the agreement sale and is entitled to his or her earnest money deposit back. You're not just breach. Yeah, go on.
What if the home inspection doesn't have anything wrong, but they want to
they can still terminate it.
They can terminate it with nothing wrong.
Well, if you have an inspection report where there's nothing wrong, I would probably fire that inspector, because there is no, even brand new houses. I sell brand new houses and their problems. If you find a property and the inspector says, oh my goodness, this is a perfect house, even the toilet's not loose, there is nothing wrong, I would fire that home inspector.
We have had it once in a while and it was
Fire
legit.
that home inspector. Don't use them again. Because if I've been involved in over 1,000 transactions in my day. And I've never seen a perfect home inspection. Inspectors will find something. I remember one of the years ago, I was selling a house, an art museum, a year early on, and it was I thought the home inspector was perfect. There was one problem. It was a loose toilet in one of the powder rooms. And this buyer would not go for it because of that loose toilet. She wanted a $50,000 credit because she bid $50,000 above it because it was a bid more, and she asked for a $50,000 credit to tighten the toilet. I said, I'll come tighten the toilet if we move forward. She said, no, I want a $50,000 credit. I said, well, according to the agreement sale is $300 to tighten this toilet. You can't get $50,000. But she walked away from the deal. So the bottom line is, I've never seen a perfect one, but if it's perfect, maybe you have maybe it's different if you have a perfect home inspection. I can't, who told me who was it that asked that? Because I'd like to know, who was that?
I did, Jody.
You actually had a home inspection and said there is nothing wrong?
Yes, well, we specialize in condominiums, so yes, we have had it occasionally.
Where there's not, interesting. So could they still back out? All right, I would still say yes. They still may not be happy with the results. Maybe they wanted something wrong. I don't know. I've never seen that happen. But if they want out, I think, I don't know. That's an interesting one because if they say the inspection, I don't know. I'd love to see a report. Okay. There's nothing wrong. Is this person still in business, Jody?
Yes. Actually, he's very good. But once in a while, it does happen.
I want to get it. I'm sure he's good. Don't tell him I said fire him. All right, because he's probably really good. I'm sure.
That will remain among the 49 people on this Zoom.
And all the thousands that will watch it once it's posted.
Exactly. So I will not disclose the name.
Don't use it in names. Oh no, don't you dare use it in names. I'm sure he's very good. And sometimes maybe there's a perfect property. I live to the day where I find it, Jody. I live to the day where I find a perfect property. All right, go back to
you.
Wait, I have another question. This is Carmen.
Yes. Go on.
Carmen, okay, so what if the buyer decides to retire from their job a week before closing? They can't get the mortgage, and can they lose their deposit?
No. Unless they lie, well, let's just say, unless they did something, let's say, well, here's the bottom line. If a lender says, I'm going to deny you, I'm going to give you a denial, I think it's hard to show that you're not entitled to your money back. If the buyer did something wrong, then I don't know the answer. I mean, did they retire because they purposely wanted to jeopardize a loan? Maybe the seller would have recourse. But if they retired because they could not work any longer, they couldn't physically do it, and the lender now denies the loan, I would, if I'm advising the seller, I would say, let's give the money back. I think you'll have a problem keeping that money in that situation unless the seller is just doing something. I would probably say you'll be hard pressed to.
I think that's what.
Now, of course, you should tell sellers. I tell buyers, don't go out and buy things. Don't go buy furniture before closing. Don't go out and buy cars. I tell them, don't even give anybody your Social Security number because we don't even want people running your Social Security. Just wait until after settlement before you go make any large purchases because it can affect your debt to income levels and may affect your credit. Just wait till closing. All right. Let's talk about number.
Trent, I have a question.
Yes, ma'am.
I had a buyer who did not want to disclose their loan information. She just felt that the seller, it wasn't their business.
Didn't want to disclose it? What do you mean?
They didn't want it on the agreement of sale. They just put the loan amount, but they didn't want any other information on there. Once they elected a mortgage, they didn't want their information.
Okay. You accepted that? Did the seller accept that?
Yes. I'm just wondering because I tried and she's also a broker. my buyer was also a broker.
I mean, that's fine. I don't know. I mean, there must be a reason. I don't know what the reason why you wouldn't want to disclose it. I've seen contracts where they would put in there that it's just they're getting a loan from a reputable lender because they don't know which one and they've got great credit and they may choose. And, so I don't, but I personally, I have to I'm not having a seller sign a contract unless I have a pre-approval. So I don't know how you would not know the name. So yeah, so tell me how that worked. If they didn't reveal the name,
No, she had the name, revealed the name, but she didn't want to put the interest rate. She just felt like that wasn't their business, even though it was a conventional loan. Minimum term, she didn't want any of that. Just the name is pretty much what she wanted on there.
Actually, just so you know, if you go back to that box, the maximum amount is actually required by the either the Real Estate License and Registration Act or the Real Estate Rules and Regulations. It's actually a requirement that you put that here because remember, if you don't have a maximum that the rate that the buyer is willing to take, then they could get out of this contract.
Yeah.
Because if you put in here nothing, then they can almost come back and say, okay, they offer me a rate of 2% and I don't want it. So I'm going to walk away and give me my money back. I would not accept a contract without the maximum interest rate that the buyer is willing to accept. I would probably not. And I know that's a requirement. I don't know who requires it, either the licensing law, the real estate license, or the rules and regulations. Let's go to number 9, change in terms. Obviously, if your buyer has a change, if they're about to retire early, or if they just bought a brand new car, or if their financial status changed, they went from full-time to part-time, they need to notify the lender, they need to notify the seller, because it may affect their ability to be able to buy this house. So, and that last sentence is something I definitely point out to buyers. A buyer in the sands that are applying for and are incurring an additional financial obligation, like a car or a house full of furniture, may affect the buyer's ability to purchase. So tell buyers, don't go out and make major purchases until after closing. Seller's representation.
May I ask 2 questions? I'm sorry to interrupt you.
No, go on.
I lose my train of thought if I don't do it now.
Fine.
2 things. One is that you said that if the buyer voluntarily changed their employment status, they would be entitled to their deposit back. But
well, no, I said I don't know. It depends on the situation. I would argue that I don't know. Let's say I was saying she said someone retired. If you're retiring early because maybe you physically cannot continue to work and now you're going to get denied, I think it'd be hard pressed to keep I don't think you would be to keep that money. I think if you go to arbitration or anywhere, you're probably going. But if a buyer is doing something to jeopardize this loan process, I think that's different. If you go and quit your job because you say, hey, I don't want this house, and I know a way to get denied, I'm gonna quit my job so I don't have an income, that's a little different. So I think it depends. But let me just say this stuff. All the years I've been in this business, I don't know any buyers who just purposely sabotage their ability to get financing to go forward with a house. I just would be hard pressed to find somebody to do that. And I think, Your Honor, it depends on the circumstances. But I have never been in a situation where someone gave me a denial letter where I didn't think that they should have their money returned, even if I didn't agree.
so then my other comment was, if you leave the lender and the interest rate blank, and let's say that lender gives them a rate that's above the market, then doesn't that buyer have to accept it because they left it blank? So wouldn't it
Well,
hurt
let's say,
wouldn't the buyer have to take that? Wouldn't it
well,
hurt
let
the
me say this.
people?
You should not leave it blank. So that question, you should not accept the contract with it blank. This is required that you have the maximum in there. So we shouldn't have a discussion about if it's blank. It should not be blank. When you get a contract and it's blank, you should send it back and ask the buyer's agent to put in a maximum because it should not be blank. All right. You should not be accepting a contract if it's blank because that's a requirement. And again, I don't know who requires either licensing law or the rules and regulations of the real estate commission. Somebody requires that be there. And I'm not sure which one it is, but it should be in your contract. So you shouldn't be accepting a contract without it. All right. Let's go to paragraph 10. Seller representations. Obviously, status of ward in Philadelphia would be public. Status of sewer would be public. Out in the suburbs could be different. I want to take the time. Let's just go through this and let's take a quick break. Let's go look at the real estate seller disclosure law. When you're required, sellers are required to complete a seller's property disclosure if they're selling a property that has 4 units or less. 5 units becomes commercial. Commercial properties does not require sellers to complete a seller's property disclosure statement. Can you help the seller complete that disclosure? Should you help them?
No, not at all.
Not at all. You should never help a seller to complete it because it's not the information that you know, is the information that the seller knows. And the seller doesn't know the answer is unknown. Don't ever have, I've always had, my practice has always been to never sit with a seller when they complete it because they're going to still ask you questions. Give it to them. I always say, take 2 or 3 days, complete it and get it back. If you don't know the answer, it's unknown. If you think you should disclose it, you should disclose it. That's what I say to them. If you have to ask a question, should I disclose blank? My answer is, I don't care what it is, disclose it. No one's ever been sued for disclosing too much information. People have been sued for disclosing too little information. I believe that over disclosure is better than under disclosure. But if you're not certain if you disclose it, disclose it. If you bring it up to me, I'm not even asking what it is. I'm going to say disclose it. Because we know that many lawsuits arise because sellers sometimes either underdisclose, don't disclose, or simply lie on these sellers' disclosures. So I tell sellers, you take your time, you take a few days, you go through every question, you answer as honestly, as accurately, and as completely as possible, and you give it back to me. Do not hide anything. This is, you disclose what you know, but you don't have to go out and do any investigation. You only require to disclose what you know about this property. If you're an executor, an executrix selling someone's property, do you have to fill out a seller's disclosure? You're the executor. Do you have to fill this out?
No.
What
Yep,
if you're the
sign it.
executor?
If you know any defects, yes.
All right. That's the answer. And I think some agents still don't understand that. One of the exceptions to the seller's disclosure law is a person who's an administrator or an executor or executrix of the estate. But if that executor or executrix, administrator or administratrix knows of any defects, then they have to disclose it. Let me just show you that because then we're going to take a quick bathroom break if you need. Look at the last page of the seller's disclosure. Maybe I have an old one. Maybe it's the first. The last page, page 10. Is that where I'm looking at an old one or recently? I don't know. You see the box that says executor, administrator, trustee signature block? Yes, no? No, yes. All right. Well, according to the provisions of the real estate seller disclosure law, the undersigned executor, administrator, trustee is not required to fill out a seller disclosure statement. However, the executor, administrator, or trustee must, and underline must, however, disclose any known material defects of the property. So even though an executor or an administrator is not required to complete a seller disclosure, if they know anything, let's say it was your mother's house, you're the executor, it was your mother's house, and you know the heater is bad. Well, you would have to disclose it. You paid the HVAC person to come out several times. Then you need to disclose whatever you know about the property. If you know the house leaks when you're there, it's leaking, then you should disclose what you know. Any questions? Any comments? All right, let's take a quick break, maybe 5 or 10 minute break. Donna, you there?
I am.
Can we do
I am.
how many, we need a 5 or 10 minute, what do we say, 10-minute break?
10.
Okay.
Yes, 10 sounds good. So it's 10:35. Let's say we're all back on at 10:45.
All right, see you back soon.
Hi, Donna.
Hi, Dina. How are you?
I'm good, darling. I just sent you a little text. I mean, a message.
Email?
No, in the chat box.
Oh,
Direct message to you.
let's see.
How come I can't get my video back on? I was waving to you and I'm not on there. Hmm?
Oh, yeah. So I left you a message yesterday, Dina.
Oh,
Code of ethics.
oh,
So
okay.
Code of Ethics, if you did complete it through CE, you just need to send me a copy of that certificate of completion. Because it is a separate requirement for NAR.
Okay, so I probably did code of ethics.
A lot of people complete it for continuing education, but we don't know that unless the member sends us the certificate. And then we upload it to your NAR record.
Okay, I don't think I did that one. I'm gonna check.
So
What did
the email has the other ways that you can complete it.
Okay, great. Thank you.
You're welcome.
Woo. All right, are we back? All right. Hold up there. All right, let's if we can turn our videos on, I would appreciate it. I know if you can. If you can't, that's fine. All right, where do we leave off? Let's go to we need to kind of speed it up. Let's go to paragraph 12. Let's talk about the inspection. Your inspections. Paragraph 12. Buyer's due diligence inspections, the rights and responsibilities. Number one, we mentioned earlier, sellers will provide access to all the, the home inspection, the home inspector, the appraiser. Sellers have to provide access. Sellers can't say, I'm not going to let the home inspector in and think that there may not be some breach. So one, sellers must provide access to the insurer's representatives, and as may be required by the agreement or by mortgage lenders, to surveyors, appraisers, inspectors we mentioned earlier. And look at this part. Only parties and their real estate licensees may attend any inspections. You should point that out to your buyer client. This is not the time to bring all your family, to bring your in-laws, your cousins, your sisters, your best friends to see the property during the home inspection. Only the parties and their real estate licensees may attend any inspections. If you want more people other than the parties named in this contract, then you should negotiate it up front. If you say, I want my parents to come to the inspection, you should probably include that in the agreement sale, because the seller can say no. The seller can absolutely say no. I remember last year, I think it was last year, I was in Florida, and I get a call from the seller because I had this property, a single house out in Delaware County, and the buyer brought 15 people with her. She was the only one buying. She brought her boyfriend. They had 2 children. She brought her parents, his parents, her aunt, her best friend, and somebody else. And then there was a home inspector, the radon, the termite. Those are 3 separate people. So there are 15 people in this house. And the neighbors called the sellers, who lives in Jersey, and said, why are all those people in the house? And she called me like, who? And so I had to call the agent and say, hey, you all have to ask all those nice people to leave. They can't have, this is not the time to look at the property. This is a time for the buyer, the home inspector, to conduct a home inspection, and the buyers should be there paying attention to what is going on. This is not the time to be all over someone's house. It's not your house yet. So be mindful of that. So you let your buyer clients know that, hey, this is not the time to bring all your family members. All right. Number 2, another important thing for buyers to know that you can make 2 pre-summer walkthroughs. All right. 2. Sometimes buyers want to go into a property 20 different times. This contract says 2. Sellers may allow you to come in more, but they can say no. And that doesn't count your home inspection, but you get 2 pre-summer walkthroughs. And clearly you want to save 1 for the day of the day of settlement. So you can go to the, do the walkthrough and then go to settlement. So you get 2 pre-settlement walkthroughs. And just because a property is vacant does not mean you can go in there as often as you want. And sometimes we know agents will do that. They'll just give a lockbox to their clients. We know that's a code of ethics violation. You cannot give access to someone else's property without their permission. You have access. You've been given access to another realtor, but you can't say to a client, a seller, or a buyer client or an investor. People do that with investors all the time. Just give you the lockbox, but you cannot do that. All right. Number 3, seller will have all heated and all utilities on for all inspections. If you're the seller's agent, make sure all utilities on. There's fuel in the tank. Make sure that, because the home inspection company cannot do a complete home inspection if if the lights aren't on or the water's not working or the HVAC is not on. Number 4, all inspections include home inspections. Inspectors are authorized by buyer to provide a copy of any inspection report to the broker for the buyer. So, and number 5, you do not have, the seller has a right, the seller has a right upon request to receive a free copy of any inspection report from the party from whom it was prepared. Unless otherwise stated here, seller does not have the right to receive a copy of the lender's appraisal report. Any reports that you conduct on a seller's property, they have a right to a copy. You don't have to give them a copy, only if they request it. Now, the home inspection, do you have to give a copy of the home inspection report to the seller, whether they request it or not?
No. If the buyer's requesting. one.
Yes.
Yes.
Let's take a look at that. Go to paragraph 13. This is something that I totally disagree with when I was on professional standards and this change. I think I made it clear that I thought this was a bad change, but I go along with whatever. I'm a team player, but I totally disagree with this. I don't think a seller should have access or should be given an inspection report if they don't request it. The contract now says that if a seller, whether the seller requests it or not, the buyer's agent must give a copy of that entire report to the seller, period. Take a look at paragraph 13. The contingency period, while we're talking about the contingency period, if it's 10 days, leave it 10 or type in 10. If you need more time, put in more time. But paragraph 13B, but these are any inspections, radon, any inspections that radon, flood, whatever, not flood, radon, home inspection, termite, whatever inspections that you choose, you have, if you leave it blank, 10 days from the execution date to get those inspections done. Paragraph B says that if the results of the inspection are satisfactory to the buyer, but 3 things can happen. The buyer can present the reports. Look at this. Even if the buyer is moving forward with this deal, they still have to present all the reports in their entirety to the seller. They can accept the property with the information stated in the report. All right. So number 1, the buyer say, hey, I'm happy with the report, the inspection report. I'm moving forward with the property. But I still, by the way, seller, here's a copy of the home inspection report. I don't agree with that, but this is what it says. Number 2, if the results of the inspection are unsatisfactory to the buyer, buyer says, I don't like this property and I don't want to buy it, the buyer will present all reports in their entirety to the seller and terminate this agreement. Remember I said, wherever you see terminate an agreement sale, the buyer is entitled to all his or her money. Because look at it, it's always going to follow that the seller can the buyer will present all reports in their entirety to the seller and terminate this agreement by written notice to the seller with all deposit monies returned to the buyer. Anytime you see terminate, the monies have to be returned to the buyer. So now, number 1, buyer does a home inspection. They're happy with it. They want to go forward. They have to still give a copy of the report to the seller. Number 2, buyer is not happy with the inspection, chooses not to go forward with this transaction, but still has to give a copy of that inspection report to the seller. And what does the seller have to do with the next buyer? Now the seller has information that they didn't know before, so they have to now either amend their seller's disclosure or give a copy, I don't know, or give a copy of this inspection report to the next buyer so they can look at it. And number 3, if the results of any inspection are unsatisfactory, then buyer will again present all the reports in their entirety to the seller, and then they can negotiate either repair credit or repairs. So they will present all reports in their entirety to the seller with a written corrective proposal, listing corrections and or credits desired by the buyer. So no matter what is presentation report something mandated by statute or something, it is something that this agreement says must be done. Now, I don't know if you can cross this out, because right now, so I don't know the answer to that, but I know that the contract that PAR uses says that we have to present it. I don't know if that's some type, I don't think that's a law or anything. I don't think so. But I would probably say if you are the seller and you know that there is a report out there about the condition of your property and you refuse to accept it or didn't want to see it, you may have some issues with the next buyer coming along who says you should have disclosed something to me that was in that report. So I think you could open up a can of worms by not accepting this report as mandated in this contract and updating your disclosure. I don't agree with this, but I follow what the contract says. All right.
Trent, I have a question. So is it PAR, professional standard forms? Are they the ones that, concluded the change? Because I agree with
Yes.
you. I mean, what's the seller at liability? Okay.
Yeah, and
something different would have to help. Something else would have to happen to encourage differently, I suppose.
Exactly. I was on that professional standards at the time of this change. And actually I got off after this change because I was so disturbed by it, because it was like, I don't understand it. I said, and I remember telling this story at this committee meeting. I said, years ago, I was representing a seller. Buyer does a home inspection and the home inspector says there's mold. So the seller says, Trent, can you find me a mold remediation person? So I found somebody. And I went to the house with the guy, and he's in the basement. He starts to laugh. And I said, well, what's funny? He said, Trent, this is not mold on the walls. This is dirt. And I said, oh. So, all right. So the home inspection report says it's mold. The expert, the mold remediation person, says it's dirt and doesn't need to be treated. Just wipe it down. And so what happens, I then go back to the buyer's agent, says this is mold, this is dirt. They said, no, we don't believe it. We terminate the contract. That's what happened. So then the next buyer comes along and we had to tell them, show them this report. And I say, here's a mold remediation expert that says that this is not mold. You know what they said to me? We don't believe your mold remediation expert. We believe the home inspector. So we want $10,000 off. And what happened? We gave them the $10,000 to close the deal. I think that hurt my client. Not only was the home inspector wrong, and the expert said they're wrong, most people figured, what did they say? Well, you hired that expert. They probably just said whatever the seller wanted. So they didn't believe it. And so that hurt the seller. This is not good for the seller. This is great for a buyer. But now a seller has to give a report from an inspector they didn't hire. They don't know any of the client. I'm assuming, most of them are going to be credible and competent, but they can make mistakes. Well, now that mistake has to be passed on to the next potential buyer who will use that to hurt my client. I'm not going to say anything more than that. But
can I just add to that? So this is why it's very important for the members to really consider coming up to the Pennsylvania Association of Realtor business meetings, so that when things like this are brought to our attention and you agree or don't agree, we're in America, freedom of speech, and you are entitled to whatever your beliefs are. But this is why we need members to show up and to participate. So I just kind of want to leave you with that, because Trent is, he's shared his opinion. I agree with him. And I've been around for a long time. So thank you very much.
You're welcome. And I agree with that. I totally agree with you. All right, let's move on. If you have for any inspections, you have, according to this contract, and let's be clear here, you have the contingency period as the number of days you have to conduct these inspections, be it in home inspection, radon, termite. Now go to 3. 3A, following the end of the contingency period. So if I have 10 days to conduct a home inspection, After that 10 days, if you leave it blank, it says you have 5 days for what we call a negotiation period. So I have 10 days that I leave this blank to do my home inspection, and then I have 5 days after that contingency period ends to negotiate any kind of repairs or credits. All right. Now, if you do the home inspection in 5 days, you just have a longer negotiation period. So you don't lose time by doing it. So in other words, you have 10 days and 5 days. You have a total of 15 days to do the inspection. You have to do the inspection within 10 days, but if you do it sooner, you just have more, I believe you have more time for the negotiation period. Because you really can't start counting until the 10-day period is over. But anyhow, so you have 5 days for negotiation period. If during that negotiation period, nothing happens or you can't agree on anything, then, and that negotiation period ends, look at B. Then if no mutually acceptable written agreement is reached during that negotiation period, or if the seller fails to respond during the negotiation period within, if you leave it blank, 2 days following the end of the negotiation period, then the buyer has 2 options. They could either accept the property or they can terminate the agreement. And of course, anytime you see terminate, look for with all deposit monies returned to the buyer. So you have 10 days. If you leave it blank as it is, the default position is 10 days to do your inspections. After the end of your contingency period, that 10-day period, you have 5 days to enter into a negotiation period. If you all can't reach you can't come up with an agreement during that negotiation period about repairs or credits, then you have 2 days after that negotiation period to either you have 2 final days to come up with it, and if nothing happens during that last 2-day period, that two-day period, then the buyer can either terminate the contract or move forward as move forward as is. Any questions? I kind of almost lost my train of thought for a minute, but any questions? All right, look at title surveys and costs. Question: if the seller has to deliver marketable title, we all agree with that because it says here. Well, first look at paragraph 14A. I think this 7-day period is a little off. Within 7 days from the execution date of this agreement, buyer will order a title from a reputable title insurance company. I would never order a title before the home inspection is done, because if we don't move forward with the home inspection, why do I want a title? And some title companies will charge a cancellation fee. I think 7 days, I mean, maybe it works for you. I always make it maybe set 10 to 12 days. 7 days doesn't seem a long time to me when I have 10 days to do a home inspection. I'm usually going to put about 15 days there. So, because if we're not going to go forward after the home inspection, there's no need for me to have ordered a title. All right. So you have, if you leave it blank, you have 7 days to order a title. If, let's say the seller cannot deliver marketable title to you, and your client, the buyer, has spent money on a home inspection, termite, radon, they've already paid in advance for the homeowner's insurance, the appraisal, would your buyer be entitled to his or her money back for those items?
Yes.
Everybody agree with that? All right. All right, take a look at 14C. The buyer will pay for the following: title search, title insurance, 2, flood insurance if necessary, fire insurance or homeowner's insurance. Number 3, appraisal fees. 4, buyer's customary closing costs. And D, a survey. We don't usually do that in Pennsylvania. Now look at E. It says a property will be conveyed with good and marketable title that is insurable by a reputable title insurance company at the regular rates, free and clear of all liens, encumbrances, and easements. F. I want to go to G. I want G. If the seller is unable to give good and marketable title that is insurable by a reputable title insurance company at regular rates, buyer may terminate. Remember, every time you see terminate, look for with all deposit monies returned. Buyer may terminate this agreement by written notice to the seller with all deposit monies returned. Look at a couple of lines down. Upon termination, all deposit monies we return, I'm sorry, upon termination, all deposit monies will return to the buyer, and seller will reimburse buyer for items specified in paragraph 14C, 1, 2, 3. Now, paragraph 14C, 1, if you look at it, that's the title insurance. 2 is flood insurance or homeowner's insurance. 3 is the appraisal. And 14D is the survey. So if the seller cannot convey marketable title to the buyer, then the seller should reimburse the buyer for all of these costs that they incurred. And I would argue, including the home inspection, because
I have a question. When you're ready, I have a question.
All right, let me just finish this.
Of course.
The seller will reimburse buyer for any costs incurred by buyer for any, look at any inspections. I would think that includes home inspection or certifications obtained according to the terms of the agreement and for those items specified as we just mentioned. Yes, go on, Joanne.
Okay, so here's a situation where we're talking about good marketable title. A buyer is purchasing a home, and they see on the seller's disclosure that no permits were pulled for the bathrooms.
Right.
They don't think much. They have the building inspection. They order the title, and they ask for the enhanced policy.
Right.
The title company finds out, or they were told, that there were no permits pulled, and they say, we can give you the enhanced policy, but there will be exceptions because there were no permits pulled for the bathroom. The buyer said, hey, this is like, we don't want this. We don't need this aggravation, and we want to terminate. What's your opinion on that?
If they can terminate because they did not pull permits, right? Basically, right?
Right, because they can't get.
They can't get the enhanced policy.
Right, it will have exceptions.
I don't know. That's an interesting one.
It is.
I have to think about that, Joanne. Somebody else? Throw it out to the
Joanne,
group.
if the title company is willing to do an exception, then they're still giving clear title. There's other exceptions even when you don't have that situation. That if you notice, the title company will write across the report exception, except whatever. So I don't see how they could do that.
So Joanne, well, what did you think? Did you represent the buyer or the seller in that situation?
No, but somebody else on our call who is not speaking did.
And what do you think, Joanne? You've been around a long time. You got a lot more experience than probably most of us in this room. But that's a tough one for me.
It is. I mean, this is an ongoing thing. The buyers have requested their money back. And I think the seller should give it to them because there are exceptions.
But I agree with that. But they won't give the money back.
Right.
See, I'm with you. If I was a seller's agent, I would say, I think you should give the money back.
Exactly. And move on.
That would be my advice to a seller. I think because I always look at it this way. Who did something wrong? Well, the buyer didn't do anything wrong. It was the seller who did something wrong because the seller didn't get permits. So my thing is, seller, you the one who created the situation by not getting permits. So I believe you should return the money and let's move forward with another transaction.
Right. Thank you.
All right. Very interesting. Huh?
I'll let you know how it turns out.
I would like to. I would love to.
Me too.
All right. Let's go to. All right. So know that if the seller cannot deliver marketable title, make sure you have your buyer submit an invoice with all the monies that he or she spent, asking for reimbursement, because again, the buyer didn't do anything wrong. If the seller cannot give good and marketable title, buyer has spent maybe $600-700 for an appraisal, maybe that much or more for home inspection, termite radon. They may have already prepaid for homeowners insurance. They may have, so, you know, so they should be entitled to that money. I'm not sure why a title company would be concerned with repair. Now, that was it. Now, did you see that, Joanne? And I actually thought about that. I didn't know who wrote that, but it said they don't know why a title company would be concerned with permits.
Yeah, I don't know, but
I was wondering about that myself. I don't know why a title company would be in the business of. I've never known a title company be asking about permits.
I think that information was volunteered. And I don't know exactly. It had to do with the enhanced policy.
It may be the enhanced policy.
Yeah, it was.
But Joanne, on the seller disclosure where it says improvements, when they said they renovated their bathroom, there's clearly a line that says were permits received. Did they put no?
No, yes, they did put no.
So then the buyer was already made aware that there were
But
no.
they didn't know that they couldn't get the kind of title that they requested. They didn't know. Yeah, that's the problem.
That's the problem, I see. Because the buyer was aware that the buyer knew there were no permits, but they wanted an enhanced policy, and the title company saying we can't do that because there are no permits, which I still understand. But hey, interesting. I would love to know how that turns out.
Me too. I'll let you know.
Hey, all right, look at 16 condos. Some of you, who was it, Jody? You sell a lot of condos. I sold a lot of condos on mine today. A condominium. You have to, if you're selling a condo, paragraph 16, you checking that. And section 3407, for those of you who haven't sold condos or will sell condos, section 3407 of the Uniform Condominium Act of Pennsylvania requires sellers to furnish buyers with a certificate of resale and copies of the condo documents, the bylaws, and the rules and regulations of the association. Now, go down to 6C. Within 15 days from the execution date of this contract, the seller's expense, must request from the association a certificate of resale. So if you represent a seller selling a condo, ask them to do this right away. Don't wait 15 days. I ask them to do it ASAP. They must request from the association a certificate of resale and any other documents necessary to enable a seller to comply with this act. The act provides that the association is required to provide these documents within 10 days of the seller's request. So if you have a condo association that's lagging, you tell them this is the law. The law, the condominium, the Uniform Condominium Act of Pennsylvania requires that they give you the resale certificates within 10 days. They all know that, but make sure if they lagging that you remind them that. Now, here's one thing that the act requires, that buyers may declare this agreement void at any time before the buyer receives the documents, the condo docs, or for 5 days after. And 5 is not underlined because this is legally mandated. This is a legally mandated period. It cannot be changed. You cannot negotiate this 5 days. All right. So before the buyer receives the condo docs, or they can void the contract, or up to 5 days after they receive them. And you can't change that. You can't say they have 1 day, 2 days. This is a legally mandated time period and cannot be shortened by any of the parties. All right. So if you are selling condos, you want a seller, if you're the seller's agent, you want the resale certificate, the condo docs early, because a buyer can back out for any reason up to 5 days after they receive them. So get the condo docs early. So if they do decide to back out, you can get it back on the market. Don't wait 15 days and now they still have 5 days. My feeling is, Jody, would you agree with me?
Yes, we would immediately, but I have another question.
Yes.
Sometimes we have a buyer and it's our listing, tell us that their attorney's out of town or whatever it is, and could they have a longer period of time to review the documents and the seller agrees to that? Is that legal, or did the 5 days supersede anything?
I know it can't be shortened, but it probably could be lengthened. I know it cannot, you can't the parties can't make this 4, 3, or 2, but can they make it longer? I would imagine they could make it longer. They just can't they definitely can't make it shorter.
That's what we thought. Okay,
Yeah.
thank you.
My reading of this would be they can make it longer because both parties agreed, but you can't agree to make it 2 days. That you can't do.
And also, I want to point out that if they don't get the documents, they can back out up until the settlement date.
Exactly. Up to the settlement date, whichever is first, whichever. Well, let's finish reading it then. Because you're right. It says the act provides that the buyers may declare this agreement void at any time before the buyer receives association documents and for 5 days after receipt or until settlement, whichever occurs first. Buyer's notice to seller must be in writing upon buyer declaring this agreement void. Again, anytime you see void or terminate, all deposit monies be returned to the buyer according to the terms of paragraph 26. So if you're selling condos, get those condo docs quickly.
I'd also like to add that the listing agent can get the buyer's email for the purpose of delivering those condo docs directly.
Right. Absolutely.
Because a lot of buyer's agents don't like to give that, but we like to give the condo docs ourselves.
And you know what? I do the same thing. I'll send them both, but I always say, I want the email. I want the buyer's email because we know they received them.
Yeah.
Because you may wait 3 days to give them to the buyer. And there are some agents who may. I know I sent them today, so they have 5 days from this day. So I agree with you there. That's actually the smart to do. Let's look at maintenance and risk of how much time we have. Seller has, paragraph 18, seller has to maintain the property in its current condition and all the appliances and all. Because you go under contract, you can't now ruin the property. You can't decide I'm just going to not take care of it. I'm going to just, it's funny, years ago, I was probably Overbrook Farms. It was a rehab. The owner was a contractor. He did a beautiful renovation. The settlement was a Monday morning. It was during the middle of the summer. And when we went to do the walkthrough that Monday morning, the neighbor said to me, they said, y'all still buying that house? I said, well, what do you mean we still buying it? I said, I have bills to pay. We better be buying it. I already spent the money. And so we go, he says, I said, well, what are you talking about? He said, well, you'll see. We go into the house. The owner, who's a contractor, his 18-year-old son had parties Friday, Saturday, and Sunday night that he charged. And according to the neighbor, there are probably 500 underage kids who came in and out of that house during the weekend, and he was charging. And there was beer. The police came about 6 or 7 times. Now, here's a beautifully renovated property. They played tic-tac-toe on all the walls. All right. The kitchen cabinet, beautiful kitchen. Some of the cabinets are ripped off. So I don't know. Some of them are hanging by the hinges. My favorite part, it had 2 full baths, but I guess when the bathrooms were full, they used the closets as urinals. So people urinated in all the closets. So we walk in and there was beautiful hardwood floors. They didn't use pants, they just urinated. I guess they used those closets as bathrooms. And a smell of beer, the beautiful hardwood floors all scratched up. And so obviously I called the agent. She comes there, the seller comes, and he says, well, I'll fix everything and we can close in a week. My client says, you can fix whatever you want. I am not buying this house that is reeks of urine all over there. Are you going to rip out all the hardwood floor and install new hardwood floors? He said, well, no, I'm going to just have them clean. And so clearly you have to maintain the property in the condition it was in when the buyer saw it. And you have to remind sellers, this is, you can't take care of the house. All right. Somebody's going to buy it. Don't ruin, don't now. Well, you all got it. Anyhow, so if let's say what happens if well, I'm gonna get into that. Yeah, somebody's gonna say something. I want to get to it. Somebody say something? Go over to go over to paragraph 23 for a minute. The Foreign Investment and Real Estate Tax Act of 1980. I think we're running. Are we running out of time? No, we got a little bit of time. Hold on a second. I think I skipped something. I thought I would. Oh no, go to 15. I skipped 15. The notices and assessment. Let me ask you this: if you are selling, if you receive an offer and is an as-is transaction with no mortgage contingency, is there a way for the buyer to still back out of this property?
Repeat that.
You submit an offer, you're the seller's agent, you submit an offer, you receive an offer, it's an as-is transaction, no mortgage contingency. Is there a way for the buyer to still get out of this property, to terminate?
Do you mean, does it have a home inspection?
No home inspection.
It has no contingencies.
No contingencies, but is there a way for a buyer to still get out?
Marketable title, since we
Okay,
talked
no,
about.
title's fine. Title's fine.
Title's fine.
Is there anything, think about it. And that's why sometimes when we get as is transactions, I tell people, be mindful of this. Think about it. You're selling as is, but what about an L&I or UNO, sir, that comes back with violations? If you're selling a property, if you're an agent, you're the buyer's agent or you're the seller's agent, and you get an offer as is, you better address the L&I violations or the L&I, sir, because if there are violations, the seller is still responsible for those violations. An as-is transaction does not mean that I'm accepting the property with the L&I violations, correct? It simply means that there's no home inspections. But now, if you're going to make it as is, then you should put somewhere in that contract that the buyer is responsible for not only getting a UNO, but responsible for any repairs or costs associated with those repairs. Don't just, because a buyer can still say, yeah, I'm buying it as is, but paragraph 15 says that the seller has to give me a UNO that is clear, free and clear of any violations. All right. Take a look at page 15, paragraph 15. 15B. We know that, and it says, if required by law, and it is, within 30 days if you leave it blank, 30 days from the execution day's agreement, but in no case later than 15 days prior to settlement date, seller will order at the seller's expense a certification from the appropriate municipal department disclosing notice of any uncorrected violations of zoning, housing, building, safety, or fire ordinances, and or a certificate permitting occupancy of the property. So if you just said, I'm buying this property as is, I would argue that this is not included. So if you want to make sure that seller and the buyer is purchasing this and as is, and is responsible for any violations that it may be in a UNO or the city cert, I suggest you put it in the contract. All right, because it says if required, I'd say if there are violations, if the buyer receives a notice of any required repairs or improvements, the buyer will promptly deliver a copy of the notice to the seller. Within 5 days of receiving notice from the city or municipality that repairs are required, seller will deliver a copy of the notice to the buyer, and the buyer will the seller will either what? Make repairs, or two, not make repairs. And if the seller will not make repairs, one, the buyer can accept the property, or two, the buyer can terminate with all deposit money returned to the buyer. So I only caution you that if you're buying, you represent a buyer and it's an as-is transaction, don't ignore paragraph 15. Make sure you mention that if you're on the seller side and it's as is, I want you to address 15. What happens? Who's responsible, A, for ordering the UNO or the city cert, and who's responsible for correcting any violations? Does everybody agree with me on this?
I do. So Trent, I had a commercial mixed-use property that we were selling as is, but we did not address paragraph 15 as far as the city search. We could have, and this is a question, could we have negotiated prior to the contract being signed, negotiated the buyer ordering the UNO?
Absolutely. And that's when you should negotiate it. Because remember,
Right.
if I'm the buyer's agent, I know what the violations are. They're public. That's not no hidden. They're not hidden. I can go on and look at the violations. And so now I'm submitting you an offer and I'm saying, yes, seller, I'm buying your property as is, and I'm going to be responsible for the violation. The buyer's accepting it with the violations, all the L&I violations. There are times when that's not in the contract, and when the L&I in the city search pool, buyer said, wait a minute, there are $10,000 worth of violations. I'm not paying that. And the seller say, well, no, you're buying it as is. And I believe that the buyer would be wrong, because you're saying I'm buying it as is. You're not saying I'm buying it as is with the violation. So all I'm saying to you is make the contract clear that if it's as is all around, and that address paragraph 15. Also, I've seen people say, I'm buying a property as is. They're getting a loan, okay? They're getting a mortgage. Remember, the bank could come back and say, I want certain repairs before we give you the loan. So if you're selling it as is, you need to address whether or not who is going to make the repairs if the lender requires them, and two, who's going to make repairs if this township requires them. So don't think as is. If there's a lender involved, if it's as is, address the fact that the buyer will have to pay for the repairs in order to get the loan. If there is no loan involved and you're selling it as is, make sure you address paragraph 15 and who's responsible for the violations, the L&I violations on this property. Don't just assume as is means that the buyer's responsible for everything.
So just to clarify, we could have negotiated beforehand that city search would be ordered by and paid for by the buyer.
Correct. And that's what I would do. If I'm representing the buyer, I mean the seller, that is, and I just had one this week, I ask the agent to go back and add in that some language in this agreement that says the buyer's responsible for the L&I, obtaining the L&I and paying for it, and for any violations, and that they're responsible for. They're responsible for correcting any violations in the city search. And of course, I already had a copy, and I gave them a copy, so you didn't have to pay for it. But I'm telling you, here it is. But if there are additional violations, your buyer is responsible. I don't want an agreement sale that just says it's as is, because then the buyer's agent comes around and says, hey, we pulled the UNO and there are a lot of violations, my buyer wants out. And I would argue you probably could get out because you didn't address this 15. You need to address this. All right. That's what I'm saying. Look at the, go to FIRSTA, Foreign Investment and Real Estate Tax Act of 1980, paragraph 23. This disposition of a U.S. real estate property by a foreign person is subject to Foreign Investment and Real Estate Tax Act of 1980, called FIRSTA. So if you represent a foreign company, a foreign organization, or a foreign person, then the title company needs to know, because when they sell, when they're the sellers, then they have to pay a tax because they're a foreign person or a foreign company. And if they don't pay the tax, the buyer will be responsible for paying the tax. All right. So if you look at it, says FIRSTA authorize the United States to tax foreign persons on dispositions of U.S. real estate interests. Further down, it says the transferee or the buyer is the withholding agent. If you are the buyer, you must find out if the seller, the transferor, is a foreign person as defined by the act. If the seller, the transferor, is a foreign person and you fail to withhold, you may be held liable for the tax. So just note, if your seller is a foreign person or foreign company, just make sure the title company, they'll probably know that, but make sure they made aware so that the taxes could be withheld, because if they if the seller doesn't pay them, then they could possibly come after the buyer to pay those taxes. Notice regarding convicted sex offenders. If your client, you're selling a property to a young woman with 2 young children who's concerned about not wanting to be on the block with sex offenders. She asked you if you could check the registry to see if there are any sex offenders on this block. Would you do it?
No.
Absolutely not.
Okay. Absolutely not is a good answer. Absolutely not. Why? Because if you do it and you miss a sex offender and that sex offender attacks her children, she's coming back to sue you. You never put yourself, I always say you put the liability on the client, not on yourself. If you say, here's the website, you can check it, but don't you dare go checking for it. And here it is in the contract. So if someone asks, and every now and then I get people asking me that, I refer them to paragraph 24. I say the Pennsylvania General Assembly has passed legislation providing for community notification of the presence of certain convicted sex offenders. And buyers are encouraged to contact the police department or the Pennsylvania State Police for information related to the presence of sex offenders near a particular property, or check the information. I tell them, go to this website, the www.pamagazinslaw.state.pa.us. If you want to know, you have to check. I refuse to check. Along those lines, if you have a family who's buying a property because their daughter is at Drexel and she's going in her 2nd year, they figure it make more sense to buy a property near Drexel and she can get roommates and pay. And the family, the mother or the father asks you, is this a safe neighborhood? How would you answer that question?
Contact the police.
Go ahead.
Contact the police. Yeah. I don't say, yes, I live in Drexel Hill. I'm not Drexel. I live in University City, and I have never had a problem. I think it's a good neighborhood. It's quiet, it's safe. And the first time the daughter or the son is mugged, they come back to sue you because they bought it, because the agent said it was safe, and we don't think it's safe. You tell them, I can get you the number or the website to the police department, and you can talk to them, or you can look at crime statistics, and you can determine if this is a safe area or not. Don't ever don't make yourself the source. Give them the information so they can don't be the source of information, in other words. Give them the resource. Don't be the source. Because my agent said is what they're going to say. But they can't say that my agent said to call the police. So nobody can come back and blame you because you said, I don't know if it's safe. I can tell you that if you want to know the safety of the neighborhood, I think you should contact the people who would know better, and that would be the police department, the people who keep crime statistics. I don't keep crime statistics. I sell real estate.
All right. On that note, I actually had to cancel a contract with an individual, a friend of mine, to be quite honest, who I'd known for almost 2 decades, because she kept A, making comments about not wanting to live around certain people, and B, kept trying to, it was just very uncomfortable and inappropriate. And then so I always recommend to people, like you said, Trent, don't get into that conversation. And
No,
I mean,
and
she went a little bit further.
And again, I agree. If you're talking, I've had clients I've had to say, hey, I want to, they bring in race, they bring in religion, they bring in, sex orientation. You say, nope. I say, nope. I don't talk about anything that deals with any protected classes. I sell real estate. I tell people, if I can sell you the house, but you have to buy the neighborhood. That's a line I've always used. I'll sell you the house, but you have to buy the neighborhood. So you have to go around and determine for yourself if this is the right neighborhood. I'm only going to sell you this house. And I'm not talking about, I cannot enter into a conversation about the race of the owner, the race of the neighbors, the gender, the sex, or nothing. We talk about the real estate, not the people who either live there, who live next door, who you think should live there, who you don't want to live there. I focus on real estate, and you're safe. The moment you start bringing in a protected class, I tell people it's like the third rail. If they bring it up, leave it alone. You shut it down and say, I cannot engage in a conversation about any protected class, race, gender, religion, creed, national origin, familiar status, disability. I cannot engage in any conversations and be done, because if there is a suit, and you never want to be on the other end of a fair housing suit or violation. That's the best say to check out about the safe in neighborhood, the police, go to the police department in that district. That's where I would say to check out, because a lot of times they're going to have it broken up by actual blocks and neighborhoods. You go to the police, go to the website of the police district in your neighborhood. That's where you're going to get the most detailed information about the crime statistics in that neighborhood. All right. Do you have to use if you're the buyer's agent and you want some work done, does it have to be done if you don't specify? Yeah, let's say you want, I don't know, I can't think of it. So you need some work done. Does it have to be done by a licensed and insured contractor if you don't specify?
Has to be done in a workmanlike manner.
Period.
It has to write it.
So
If
they
you want
stop there. Just stop there, because that's the answer. That's exactly what the contract calls for. Take a look at 25C. That's exactly what it says. Any repairs required by this agreement will be completed in a workmanlike manner. That does not say licensed and insured. If you want it to be licensed and insured, then you better make sure you put it in the contract that it has to be done by a licensed and insured contractor. Otherwise, it simply needs to be done in a workmanlike manner. And that's a professional manner. Okay. That's not, it doesn't have to be, but if you want it done by a licensed insured contractor, you should specify that. All right. If you have a dispute, this contract, paragraph 27 says we must go to mediation first. Okay. Buyer and seller will submit all disputes or claims that arise from this agreement, including disputes and claims over deposit monies, to mediation. If you go further down, it says legal proceedings may be initiated prior to the completion of the mediation process to stop any statute of limitations from expiring, and for the purpose of indexing a list pending by buyer to present. So, but you can file a legal action just so, because you don't want the statute of limitations to run. But if there is a dispute, this contract mandates that we use mediation. Mediation, of course, is a less effective way to resolve conflict. You don't have to spend money on attorneys. It's an easier, friendlier, less effective mechanism. So, but if there's a dispute, you can't run to a lawyer first, because you should, if you got a lawsuit, you should contact the lawyer and say, hey, the contract says that they must go to mediation before they go and file a lawsuit. All right. Real estate recovery fund. Communicator. I'm just going. There was something I wanted to. Oh, something I was saying. There was something I wanted to say. Can you? All right, go over to the last page. Buyer and seller acknowledge a copy. Now, this is something I think a lot of agents still, well, now it's easier now with all the technology, but do you realize, or do you know that when you meet a client out, well, let me ask you this. Let's say you met a buyer at Starbucks, and they signed the agreement sale. You don't have an extra copy to give them. You said, I'm going to give it to you when I'm going to email it to you when I get back to the office. Is that appropriate?
No.
When do you have to give them a copy of that agreement sale?
They sign it.
At the time that they sign it. Otherwise, you actually is a violation, one of those, remember those prohibited acts, section 604 of the Real Estate License Registration Act. You must give, anytime a client or customer signs any documents, you must give them a copy at the time that they sign, not an hour later. I mean, if they could take a picture of it, that's fine, because they have it. but you cannot say, I'll mail it to you, I'll drop it off. If you meet anybody outside of the office, always take 2 copies. Never take 1 because you're now violating the licensing law. You must, and look at the contract, it says buyer and seller under special clauses for the sentence. Says buyer and seller acknowledge receipt of a copy of this agreement at the time of signing. And this is, like I said, required by the Real Estate License Registration Act. And so you don't want to have people, clients or customers signing documents and they have not been given a copy. All right. Always take 2 copies if you're going to meet somebody outside of your office. Obviously, if you're in your office, you just make a copy from there. Can this agreement be signed in counterparts? In other words, can I have 1? I can make 2. I can make a copy of this agreement, send it to you in California and you in New York, and put them together. Can I do that? Is that fine? I have 2 sellers. 1 lives in California, 1 lives in New York. I send the same contract to both. They sign it separately, and I just put them together. Can I do that? Is that okay? Or do I have to sign the same document?
I think it's okay.
It's okay. That's what a countersign is. A counterpart is. If you look at this, this agreement may be executed in 1 or more counterparts, each of which shall be deemed to be an original, and which counterparts together shall constitute one and the same agreement of the parties. So yes, you can have the same, as long as it's the same document, it can just be signed separately by different parties and then just put together as one document. All right. I would rather, obviously, that you sign the same one and not have to do it in counterparts. I think there's any questions, any comments on anything?
Thanks, Trent. I take this every time you teach it. I really enjoy it. I always feel like I learned something, or I knew something I didn't know that I knew. So it's a great workshop.
Well, I thank you. I appreciate that.
I second that, Trent. This is the second time I've taken it. I always learn something.
Well, thank you, Joanne.
More than one.
Can I get a third person?
Yes,
I agree.
I agree.
And a 4.
Can I get someone send me Cash App?
Now we're gonna go to the real estate commission.
Oh,
No,
never
but
mind.
thank you, Trent.
Never mind. I was just about to put my Cash App and never mind about the Cash App.
Thank you, Trent. You're excellent as always.
All right, well, I appreciate it. Any questions or comments?
I have a question.
By the way,
May I?
we are doing the next month. I'm doing the buyer agency one. We just scheduled. Donna, what was the date we chose? Are you still there, Donna? I think the 24th of January. We'll do a buyer agency one because, of course, that's probably one of the biggest changes since the NAR settlement agreement. So we'll do the same thing, go through every paragraph. I feel like I left something out, but I appreciate it. If there are no other questions or comments, then I wish you all the best and have a great day.
Thank you.
Thank
You
you
too.
very
All
Excuse
right.
me.
Thank
May
you.
I have a question?
All right. Same to you.
Yeah.
All right.
Excuse me, may I have a question?
Absolutely.
Yes, it's regarding on paragraph 12.
Yes.
There are sections for the property boundary, the zoning.
Wait, paragraph 12, what paragraph?
Like the D restriction and zoning,
Okay, yes.
and also the boundary. Okay, for
Yes.
some of the buyers, since they waive everything, right?
Uh-huh.
But if for the mortgage that dealt with any of those issue that not approve
Right.
their mortgage. So in this case, is the buyer obligated to buy it, or is always good to just check elected in those two
Now,
areas?
I actually think what you said is a good point. If you would, let's say, if you elect, let's say you waive, let's use an easy one. Let's say termite. Let's say you waive termite on this. So you say you're not doing a termite, but you get a loan and the bank requires a termite search. Then, and if they're termites and they're not treated, the bank will not give the loan. So the buyer could back out because of now the loan, the buyer can't get the loan unless there's a clear termite search. So yeah, the buyer can say, you know what, my lender is requiring this. And remember, the contract says if there are repairs that the lender requires, the seller will either make those repairs at the seller's expense, or if they won't make the repairs, the buyer has two options: either make them themselves at their expense or terminate the contract and get their money back. So even though you waive something, and if the lender requires that it be done, it still needs to be done. Depends on who pays for it or who does it. That's negotiable, but it still needs to be done. And if it's not done, the lender can deny the loan and the buyer would then be entitled to his or her deposit money back. Is that what you're asking?
Yes, yes. Thank you for the explanation. Because my experience was then some of my buyer that they waived most of the home inspection, radon and termite, but then they still want to keep the boundary and deed. And the listing agent in a couple scenario, the listing agent for couple listing agent, not only one, asked me, what does the buyer wants to do with the zoning, or they want to build an addition or whatever. I said no, they have no plan, but they want to keep the right to just in case there's any issue come out.
Well, and you know, now if you check this, if you elect, oh, let me just mention this too, which I did. If you elect or waive any of these, don't use X's. Have them initial. Because if you have an X, what happens if that's a mistake? And you don't want a buyer to come back and say, wait a minute, I didn't mean to waive termite. But if they initial waive, is different. I never allow X's here because it's too important. I think it's best to have them initial what they're going to do. All right. But let me go back and say, so let's say you elect, the zoning that you were talking about, or deeds, the zoning, if they, remember you already have in paragraph 6 a zoning classification. So if the zone is wrong, the buyer can already get out. But you can make this contract contingent upon the zoning classification that the seller that's in the contract to be correct. So look, take a look at this one here. It says the second line, it says buyer may verify if you elect zoning, deeds, restrictions and zoning, buyer may verify that the present use of the property, such as in-law quarters, apartments, home office, daycare, commercial, recreational vehicle parking is permitted, and may elect to make this agreement contingent upon an anticipated use. So this is simply saying, I want to verify that the zoning classification that you said this is actually correct. And if it's not, or I want to be able to, my client wants to use this as a daycare, and I want to make sure that the zoning that you say this is will allow my client to operate the business that my client wants to operate. So you basically, by checking this one, you're verifying that the use is permitted. So you don't want to buy a property and your client wants to open daycare, is zoned as a daycare, but you find out it's not an allowable use. Now, what I would say if you ever want to have anything, if you want it zoning, I'm trying to say, there's a zoning approval contingency addendum to the agreement of sale. I would use that addendum. If you have any issues or concerns about zoning, use the zoning approval contingency agreement, addendum to the agreement of sale. Because there are 2 boxes on it. The first is verification of zoning for proposed use contingency. So you're saying that the buyer at buyer's expense may verify that the buyer's proposed use of the property as blank, whatever it is permitted under the current zoning classification for the property and is not prohibited by any other governmental land use restrictions. So this allows you to verify that the use that your buyer wants to use is permitted, and if it's not, you can back out. There's also a second one here if you want to change the zoning to use it for something else. I want to get into that, but I would use this zoning. It's called the zoning approval contingency addendum to the agreement sale. Is form ZA and zip form. Z as in zebra, A as in apple. Zip ZA. All right.
Yes, thank you.
Any other questions or comments? Not. Let's see. Now one last thing and then we won't go. Now, make sure if you are the seller assist part, I didn't mention that's on the seller assist. Go back to paragraph 3. Paragraph 3. The seller assist. Don't make the mistake of, if you're representing a buyer, make sure you know what the maximum seller assist is allowed by the lender. If you have an FHA loan borrower, what's the maximum seller assist? Everybody knows that, right? What's the maximum seller assist allowed by the lender?
6%.
6%. So if your buyer is FHA and you ask them for 6%, we know that's allowed. You don't even have to ask anyone because that's allowed under FHA. What is it under VA? If you're the VA buyer, what's the maximum seller assist? It's 4%. FHA loan is 6%, VA is 4%. All right. Now, if you put, let's say, 8% seller assist and it's FHA, the lender can only give 6%. So you don't want, well, let me finish because then what about commercial? Conventional. What's the maximum seller assist allowed on a conventional loan? Anybody know? It depends would be the answer. It depends. If you put in down, depends on your down payment. If you put in down less than 10% on a conventional loan, the maximum seller assist is 3%. If you put it down less than 10%, the maximum seller assist is 3%. So you want to put in the contract more because the seller comes back and says, wait, I can't give you 4 or 5. I'm going to cut it to 3 and I'm not giving you anything else. So you as a buyer's agent, make sure you understand that. If your down payment on a conventional loan is 10% to 25%, then the buyer can get a maximum of 6% seller assist. If it's under 10%, they can get a maximum of 3%. If it's 10% to 25%, they can get a maximum of 6%. If they put it down 25% or more, they can get actually up to 9% seller assist. A maximum is 9%. And for any investment property, the maximum is 2%. Any investment property on a conventional loan, the maximum seller assist is 2%. All right.
What about one question? What about the commission, the buyer agent commission? That is not seller assist.
No, that's under paragraph. If you go back to your agreement sale, that's under that's buyer broker fee. They split under, it's still under seller concessions, but it's been divided. The A is buyer broker fee is the commission that you negotiate. And the closing cost assistance, that's your seller assist. That's that maximum seller assist you can get that I just mentioned. But those are two separate things.
Okay, thank you.
You're welcome. You're welcome. All right, if nothing else, I thank you all. If there are no other questions or comments, then, all right. Can you, hold on one second.
All right.
Thank you so much.
All right, so that concludes today's class. Thank you so much to everybody for attending. Pay attention to your inbox for further presentations that we'll be having and ways to register. And if I don't see or speak to everybody, everyone, please have a happy holiday.
Same to you.